All right, guys, we're working on getting everything set up. We're going to be broadcasting today. Let me just get the Facebook set up if I can. Always the most difficult part. All right, hopefully, well, don't get Facebook, we don't get it. Okay, guys, hey, this is a big day in the Karen Reed case, as everybody knows. Today is a pre-trial hearing. There's been a lot of stuff that's been discussed. Yesterday, Karen and her lawyer went on the media. They went on the Today Show. So there was some new information that came out about that. We're going to be broadcasting the hearing. We're going to be streaming the hearing when it comes on. I think it's scheduled to start at 2. Oh, good. Thank you, Tom. You can hear us on Facebook too. Wow, that's a first. That thing usually doesn't seem to work, but this is going to be a very long day, but we got some good stuff going on. Dave is on site at the hearing, or he should be arriving any minute. And as soon as he's comfortable, he'll come on. He's got to try to, unfortunately, he's only got one phone. We hadn't planned ahead. So he's got to try to save his energy so he can cover as much as he can in the rally this morning, which Turtle Boy's rally starts at 12:15. And then Dave's going to try to get charged up so we can do some stuff after the rally. So what I thought we could do, we'll talk about this for a moment, but obviously you guys don't want to hear me talk about this all day. So what I thought I would do, if anybody is okay with this, is put on a little bit of replay from the hearing from May 10th or whatever the date was. So I've got that here. So we're going to probably just add that in. But we'll be here all afternoon. So you'll be able to check in here and see the hearing. You'll see Dave down at the rally. Obviously, you can go to Turtle Boy's site and see the images that they have from the rally too, but you'll be able to comment here. Tom says the Facebook stream is behind by a few seconds. I'm just glad it's going, man. That seems to be so hard to get going. But hi, Benjamin, Karen, Liz, BL. BL is a diehard. He's always here with us. Sue, hi, nice to meet you. So we know it'll get going. This is a long day for me. Actually, if somebody here really wants to go on and share the screen for a little while before 2, just send me a message and I'll send you the stream link and you guys can come on. But for now, what I want to do, I'll just take maybe a couple minutes to answer some questions and give you some updates and some things that are going on. And then we'll go to, I'm going to replay that hearing, like I said. And I was just looking at it again myself today. And there's some really interesting things in there that I didn't even really necessarily catch the first time. So every time you go back, especially once you've been thinking about a case, you go back to that hearing. There's little bits and things that come out that can strike you as really interesting. So I talked to Sean today, McDonough. He's going on with me tonight at 7:30, and he's now become kind of a focal point for getting information. Obviously, a lot of Turtle Boy has a lot of sources, but Sean. And you saw last night, if you watched the show that we did, Sean wasn't even on, and this guy came in there that was attacking him, digging around dirt. So obviously he was sent in by the opposition, which tells me maybe Sean is over the target. But Sean sent me today some photos. One of them we'd all seen before, but 2 of them I had not. They were very compelling, and one of them, he told me, he insisted I cannot give it to anybody else. I cannot share it. I cannot broadcast it. So hopefully by the time he comes on at 7:30, we'll be able to show that last photo, because it is really potentially revealing of, to be honest, a conspiracy. I mean, you hate to use that word, but again, you guys know me, and I know a lot of people get angry about it, but I try to really keep a little distance to try to find out what exactly is happening. Because I know we're getting sent information primarily from one side. That doesn't mean that side is wrong. It just means it's a smart thing to understand that the defense team has a job, and that, the witnesses that they get to testify. I don't know if you guys have ever been to a trial before or sat on a jury. You could see these on TV too. And so let's say it's an injury suit, an injury lawsuit. And so, a lot of that stuff goes on. I've been on 2 of them. And, whether they're real or not, a lot of it tends to be, the person who is suing the plaintiff has to convince not only that the defendant did something that proved them liable, but also that they have to prove the extent of the damage that was done to them and the injuries. So in order to do that, they bring in medical experts, doctors that testify. And one of the things you'll see that happens is they first have to introduce this guy, and then during cross-examination, the defendant's lawyers will go over his history with him, not just his qualifications as a doctor, but how many trials has he testified in, and how much is he getting paid. It's all valid, and that goes into it's all part of the record. So when you're on the jury, you have to weigh that, because what's going on is it's become an industry for a lot of people. There are doctors that make a living or make a good chunk of their living testifying in trials. Doesn't mean what they're saying is dishonest, but you have to kind of take that into account. Now, I'm not saying that that's the case here with any experts. Thank you. TB is live now. So feel free for anybody that wants to switch over. We'll be here all day. But anybody that wants to whenever you have an expert come in like that, he's being handpicked by the defense team because they can count on his testimony. And so when you look at this case here, it's the same thing. So any experts that the defense is going to hire, they're hiring for a reason. Again, that doesn't mean what they're saying is wrong, but you have to to me, it makes sense if you're going to do that to at least wait to the trial and hear both sides. And I'm telling you right now, in my life, I'm not an expert at anything except making a Bloody Mary. But in my life, and I'm 57 years old, I've had a lot of experience at being in the middle of disputes and try to handle what's fair. And if a lot of times you'll get information in the early going that you do these aha moments. You're like, oh my God. But if you don't wait for the other side, because then if you wait for the other side, a lot of times you'll get that information and you're like, maybe it's different. So it really does pay to get both sides. So let's switch over to the old hearing. Let me see if I can, give me a moment while I do this. Share screen. All right. Okay, so this is Adam Lally. This was from I forget what date, but it was in May. So let's go over. This is fascinating.
I can hear you over here from there, please.
So, Your Honor, the Commonwealth requests that the defendant's Rule 17 motion be denied. This isn't a situation where the Commonwealth is afraid of evidence being produced or desperately afraid, as I believe as it was characterized. It's simply that counsel and the defendant need to.
Oh, sorry. Obviously, you're not a guy.
State actual facts and actual evidence, as opposed to the fanciful fact section that's been submitted to the court. This case does not, as counsel suggests or states pretty plainly, hinge solely upon the testimony of Ms. McCabe. The statements and testimony of other witnesses, the forensic evidence, the video evidence are conjunctively simply hard to reconcile with counsel's facts, even assuming everything appeared in their motions and affidavit is true and accurate, which I submit that it's not. The predominant amount of statements made by the defendant to this witness, being Ms. McCabe, were made by the defendant in the presence of additional witnesses, which is conspicuously absent from counsel's recitation of those facts. Counsel states in the motion that the defendant, quote unquote, has always maintained the purported story of her leaving Mr. O'Keefe at the Fairview residence and calling him repeatedly to ensure that he was safely within the home. The defendant, over the course of the investigation, said a lot of things to a lot of people. She talked to a lot of civilians. She talked to a number of troopers involved in the investigation. This story was never presented, not once. She did present varying accounts to varying people as far as when she last saw Mr. O'Keefe, what happened with Mr. O'Keefe the last time that she saw him, but never this particular version of events. The defendant seems to suggest that the body of Mr. O'Keefe was discovered that morning by the defendant and Ms. McCabe. However, Ms. Roberts was present with them at this time as well, but remains absent from counsel's recitation of the facts. Counsel further states that Ms. McCabe, quote unquote, inserted herself into the defendant's search that morning for Mr. O'Keefe. However, it was the defendant that awoke the victim's niece at approximately 4:30 in the morning, had the niece repeatedly call and text Mr. O'Keefe, and then asked for or instructed the niece to call Ms. McCabe at 4:53 in the morning. So this suggestion that Ms. McCabe is up all night pacing around her bedroom, or that she's shockingly awake at 4:53 in the morning and answers this call from the defendant. She answers the call from the victim's niece, and then the victim's niece, at the instruction of the defendant, puts the defendant on the phone. And that is how this search, or how this issue begins. The defendant initially tells Ms. McCabe that she last saw the victim at the waterfall. When she's then subsequently informed by Ms. McCabe that she had seen, being Ms. McCabe, had seen Mr. O'Keefe and the defendant leaving the waterfall together, and further seen the defendant's vehicle in front of the residence on Fairview, the defendant then indicates that she left Mr. O'Keefe on Fairview after they had gotten into an argument. These aren't just statements that Ms. McCabe testified.
Just want to pause here for a second, guys. So this is something that I hadn't really paid attention to before. So what the prosecutor is saying here is that according to McCabe, and apparently according, this was backed up by, I think by what John O'Keefe's niece heard. What they're saying is that McCabe is that Karen Reed initially told Jen McCabe that morning at like 5 a.m. that she had last seen John O'Keefe at the waterfall, the bar downtown. And then McCabe said, well, no, I know you were there because I saw you outside and I saw your vehicle outside. So then at that point, Karen said, oh, yes, that's right. I dropped him off at the house. This to me is the problem with witness statements, and they're coming through a filter here. In this case, the prosecution, it's coming through witnesses. A witness testimony can get influenced. You just have to take it all with a grain of salt and just kind of store it in the back of your head and see if it's meaningful later. But to me, statements like that don't really mean much to me, but it is interesting.
These are statements that the niece overheard while Ms. Reed was talking to Ms. McCabe on the phone. She provided an interview, a sane interview due to her age, and indicated and corroborated those statements Ms. McCabe attributed to the defendant. The delay that counsel aveers in the motion that Ms. McCabe caused in Ms. Reed's frantic search or trying to get to the residence on Fairview, the evidence demonstrates from Mr. O'Keefe's ring video that the defendant left Mr. O'Keefe's driveway at approximately 5:08 in the morning from the ring camera. She does not arrive for approximately half an hour later at Ms. McCabe's home. And the information from her phone and the information from the video from the Canton Public Library and from the Temple indicate that during that time frame, she travels towards the waterfall. She travels in the direction of the Fairview residence. So any delay that was caused in her getting to that residence with Ms. McCabe and Ms. Roberts was her own doing and not that of Ms. McCabe. Now, the defendant also states that Ms. McCabe stated to Trooper Proctor that while they were searching for Mr. O'Keefe, the defendant repeatedly asked, could I have hit him? Did I hit him? The defendant also repeated these statements when the body of the victim was discovered, as reflected in the testimony of Ms. McCabe. It's also reflected in the testimony of Ms. Roberts. It's also reflected in the testimony of first responders, paramedic who was standing directly next to the defendant when she said these things in response to the paramedic's questions. The further statements that Ms. McCabe attributes to the defendant while they're driving around were also corroborated by Ms. Roberts, because Ms. Roberts is on the phone with them on a Bluetooth while Ms. Roberts is driving her vehicle and Ms. McCabe is driving Ms. Reed's vehicle from Ms. McCabe's house back to Mr. O'Keefe's house. So all of these statements that Ms. McCabe has purported to have created are corroborated by other witnesses, by video, and by forensic evidence. The new revelations or the new evidence that counsel aveers was withheld from the defense that Mr. Green has apparently uncovered is specious at best. It's from the affidavits or the reports that were subsequently done by Trooper Garino and an independent forensic expert that our office hired in regard to this, whose qualifications are contained within the attachment that I filed with the court, approximately a 21-page resume that she has in this particular field. She teaches in this field, she writes in this field, and she comes to the same conclusion that Trooper Garino does, that those Google searches that are attributed by Mr. Green as happening at 2:27 and 40 seconds in the morning did not occur at that time. They were a result of the file being parsed from a write-ahead log or a wall file. The analogy that I would make as far as Mr. Green's analysis of the phone is very similar to counsel's recitation of the facts. It shows you one thing, but neglects to put it in the context of the rest of the facts, neglects to put it in the context of the remainder of the evidence. And what Mr. Green does is, yes, there is an indication in the phone that there is a search at 2:27 and 40 seconds in the morning. However, if you look behind that data as to when that entry was actually created, it's 6:23 a.m. and 6:24 a.m., which is while Ms. McCabe is on the scene in front of the Fairview residence with the defendant, conducting that Google search in response to the defendant's request to conduct that Google search, or to Google hypothermia or something to that effect. As far as these deletions within the phone, both forensic experts, being Trooper Garino and Ms. High, indicate that these deletions are not something that is actively done by the user. So to simply say, oh, this information was deleted from the phone is not an indication that Ms. McCabe deleted that information from the phone. It's something that happens as data is stored, as data is set aside to such things as this wall file. There is a search at 2:27 and 40 seconds in the morning, and it's in relation to Ozone basketball. Now, Ms. McCabe also testified that the night before going to the waterfall, her and her husband had gone to one of her daughter's high school basketball games. She indicated that her girls play basketball, girls play sports. She's checking scores, she's checking standings, she's checking stories about her child's basketball game at 2:27 in the morning. And essentially, the best way that I can describe it is this. If you were to open up the Safari app on your cell phone and you engage the Google website and you do a Google search, then you close that Safari tab, the Safari application, you put the phone down on the desk for 6 hours. You pick up the phone again after that time has elapsed. You go back to the same Safari tab and you go back without creating a new tab or a new website. You go back and do a subsequent Google search. That subsequent Google search that you're doing at, say, 6 p.m. is going to reflect in the phone as being done when the website was first visited, when Google was first visited, that's 6 hours before. That is what happened in this particular case, and it's borne out throughout the affidavits and reports from the various forensic experts in relation to that. Now, as far as the phone calls to the Alberts from in front of the house.
I just want to pause here for a second again, guys, because we keep having this debate about the phone. It got heated last night on the channel. Lally is very clear there that the state now has an independent expert that confirms, in her view, her name is Hyde, what Trooper Garino found. Now, I'm not saying I believe that. I'm not saying you should believe that. I'm just saying it's not really like I've heard people say that she says it's not clear. I don't know where that comment came from, but and maybe she isn't. Maybe Lally's misrepresenting what she said, but that would be very unusual for him to do that in front of a judge, even though he's a little bit shady. I don't know. That seems. But so you have here is definitely there are experts on one side and an expert on the other. So to me, that's why I believe you wait and see what is said. I even played with this on my own phone today. Me and Sean did it on his, working with the Safari and the tabs, and I can kind of see what they're, I can kind of see what they're saying. But again, I can see what the prosecution is saying. But again, I'm not an expert, so I don't really know. It seems to me very strange. Obviously, Rich Green is not going to be confused about that, or any kind of data expert. So for me, it's like, all right, let's just see what happens at the trial. And I have not seen any other experts coming forward to explain this, to clarify it for us. So I don't know. To me, it's not straightforward, not yet. So let's go back to playing this hearing?
Yes, there are phone calls reflected in the phone. There is no deletion of Mr. Brian Albert's contact information from within the phone. It's still in the phone. It was in the phone when Trooper Garino did the extraction on May 4th of 2022. It's still in the phone now. The phone calls, I think, are perfectly sort of understandable in the sense that Ms. McCabe is in front of her sister's home, finds her friend lying on his back, struggling for his life, and she makes a phone call to her sister. The phone calls durations, they do list as answered, but so do calls when they go to voicemail. They list in the phone as answered. And the duration of the calls, I think, is telling. And that the first call at 6:07 and 42 seconds lasts for a duration of 9 seconds. The second call at 6:08 and 17 seconds, which also lists as answered, lasts for a duration of 7 seconds. These are calls that are going to voicemail. And then subsequent to that, at 6:23, Ms. McCabe makes a phone call to Brian Albert, which lists as unanswered. The last, as far as the health data, I don't want to keep reiterating this. I spoke about it on the last court date, but the health data for Mr. O'Keefe's phone has him taking 133 steps at 8:08 in the morning, 68 steps at 8:25 in the morning, 87 steps at 7:57 in the morning, 81 steps at 11:06 in the morning, 109 steps at 11:18 in the morning, and then 46 steps at 11:56 in the morning. The issue with that, as far as being able to rely on any of that data for anything whatsoever, is that Mr. O'Keefe was pronounced deceased at the Good Samaritan Hospital at 7:50 in the morning. So all of these steps, all of these feet, all of these things that he is.
I got to pause again here because this still pisses me off so much that Lally would try to insult our intelligence by saying that. I mean, it really pisses me off. I stay objective in these cases, but for him to say that to a judge, to a jury, in front of bailiffs that swear people into court to tell the truth, for him to sit there and insult our intelligence by using that as as evidence that the health app data was unreliable based on the fact that that data showed John O'Keefe moving around. I mean, everybody understands that the cops picked up the phone. I mean, it's just crazy. I know. Thank you, Julia. I mean, it's not just wrong. It bothers me. It's when your argument is that weak that you have to make something, it does make your case suspicious. So let's go back to it. Little lunchbox Lally. I don't know. Is he a sympathetic figure?
Is traveling are after he has passed away. Furthermore, as far as the 3 floors going up and down within the house, in Trooper Garino's report, he details as far as looking a little bit deeper, a little bit more than just, the phone or the health data indicates that he went up or down 3 flights of stairs. What it also indicates from Mr. O'Keefe's phone, from the GPS information, is that he did a Waze search because he had never been to 34 Fairview Road before. He does a Waze search to try to locate him. Now, that GPS information from his phone has, at the same time that he's going up and down 3 flights of stairs, he's more than a half mile away from the residence at that particular time.
Now that is interesting. So once Lally's already done that by talking about the phone app data, the health app data, when clearly a cop had picked it up. And now I don't trust. Once you see that, you're not going to trust him. And I think if he tries to do that with a jury, the jury's just not going to believe. He's lost the case right there because the jury's not going to believe anything he says after that. But that was an interesting point there, that the GPS data from the health app showed him moving around at the same time that the Waze data showed him a half mile away. But there are going to be technical explanations for these things. For instance, my understanding is that these cell phone towers are pinging not every second, but at kind of regular intervals. So, I mean, there's going to be some kind of an explanation by the defense on that case there. They're going to be able to explain it. And that's why we have to listen to the competing experts come in. There's no other way around that. There's no neutral source here. I mean, I wish we'd see more stories on this, but maybe if this case becomes, and it looks like this case is going to become as big as the Murdaugh case. I really think so, especially the more that it looks like when you look at it. Well, I don't know if we'll be able to, but some of the pictures that Sean sent me today, if he's able to share any of them with you, I mean, it makes you angry. It makes you suspicious that something really messed up is going on here. So if it gets to that point, I'm hoping that you'll get more objective experts in to talk about that data, not someone that's trying to push one side or the other. But for now, all we can do is say, let's wait for the trial.
It also gives speed. He's traveling at a certain distance, meters per second, that's encapsulated within Trooper Guarino's report as well. None of that health data is even remotely accurate. Now, furthermore, there is a supplemental report, which I filed as an attachment to the Commonwealth's opposition that Trooper Guarino conducted in regard to certain measurements and GPS locations from Mr. O'Keefe's phone. And what they show is sort of concentric circles as far as the distance that the person could have traveled from that in those specific time frames. And essentially what it boils down to is there is a total of 3 seconds, 3 seconds, in the entire time that Mr. O'Keefe is in the area of 34 Fairview Road, that any of those concentric circles even touch the house of 34 Fairview Road. And following immediately from those 3 seconds, the circles are able to then be condensed and more accurate information is generated in relation to putting him exactly where he was found at 6 o'clock the next morning by Ms. McCabe, the defendant, and Ms. Roberts. And again, another statement attributed to Ms. McCabe is that Ms. Reed was the only one who could see in the blizzard conditions, which I know the court has reviewed in relation to Officer Sharaf's cruiser camera footage of his approach and arrival at the scene, which is almost around the same time as the 3 ladies would have been approaching 34 Fairview. But the point being, again, is a statement that Ms. McCabe is, the only one who said that the defendant said this, or the only one who describes this reaction by the defendant as being the only one who could see Mr. O'Keefe laying in the snow, covered in snow from that distance in the dark in a blizzard. But unlike in the recitation of counsel.
Sorry to interrupt, but again, that to me is absurd. When the prosecution has to offer things that are absurd and are useless, so they're trying to say here that it's somehow evidence against Karen Reed that Jen McCabe was surprised that, wow, we couldn't see that body, but Karen Reed knew because she was like, there it is. It's absurd. I mean, those kind of witness statements are useless, and I'm really disappointed that these guys even use it, and it does kind of suggest they have a weak case, because to me, if I'm Karen Reed, even someone with the minimal education and intelligence level, and this woman's teaches college courses. I think she's a professor or an assistant professor. So picture you're in the car. Let's say she's guilty. Let's say she knows John is there, and she's got these 2 people, and she's driving. They're driving to there. Kerry Roberts is driving. So everything that she's thinking, every fiber of her being is now getting into a role. I've got to pull off the idea that I'm shocked to find John there. Okay. So if that's the case, she definitely knows that she can't be the first one to see John in the snow. I mean, to me, if Karen really was the first person to see John in the snow, that actually suggests she's innocent. I mean, it's just a weak indicator. But to me, if it indicates anything, it indicates innocence on her part, because she's not going to. I'd be like, oh my God, I mean, I would pretend I wouldn't see it. I'd be the last person to see it. That's what you would do. I mean, it's kind of like the same thing with when she eventually makes a statement to the effect that, did I do this? Did I do this? Could I have hit him? Well, to me, that suggests innocence, because you would never do that if you knew that you were guilty. Like if they're charging her with 2nd-degree murder, which is basically that she not only hit John O'Keefe, but left there on purpose, knowing that he was dead or dying or injured. And that's, if you're going to do that, one thing that you're not going to, the last thing you want to do is point a finger at yourself and say that it was even possibly you. I mean, maybe you might do something like, oh, I wonder if he was hit by a plow, or I wonder, I should have stayed here. Maybe he tried to walk home and got hit. The very last thing you're going to do is say, was it me? Was it me? I mean, so it's just kind of crazy to me. Just got a text from Dave. He is stuck in traffic trying to get there. So I'm not sure what time we'll get on, but he'll be there all afternoon. He'll be there during the hearing and after the hearing, and he'll be penetrating the Turtle Boy crowd. But apparently, I'm not sure. You guys can tell me if you're watching Turtle Boy, but apparently there's supposed to be some people there from the other side too. Let me just check comments real quick. BL says the time really bothers me on both sides. Doesn't match up events. All right. Now, Thank you for at least trying to think this through from both sides, BL, because that's what everybody should be doing in a complicated case where it's not really easy to figure out what happened. None of the scenarios here portrayed by the defense or the prosecution, and they've all floated multiple scenarios because none of them add up. So we have here a very complicated case that nothing makes sense. But John O'Keefe is dead. He is dead. So something happened. We can see the wounds in the back of his head. So he didn't just fall asleep there and fall asleep peacefully. He was killed, murdered, something happened. So we got to get to the bottom of it, but we should keep an open mind towards the evidence that's coming in. So Kid Check Rhyme is saying, as long as procedure is followed, there is no expectation of justice. I'll be tuned into this one. Nothing adds up yet. I'm not sure what the first comment meant. What you meant by that? As long as the procedure is followed, there is no expectation. I don't really understand that, because if you're following, we want the cops to follow procedure, right? So I don't know. I'm not sure. I'm sure maybe he's talking about the trial. So, but then I'll be tuned in because nothing adds up. Exactly. That's what you got to do, Kid Check. I mean, we don't know what happened here. People can have powerful opinions one way or the other. I mean, for most of the time over the last 3 months since this story broke, I strongly lean towards conspiracy. I got some powerful evidence this morning in photos sent to me by Sean that suggests conspiracy. But I don't know. I mean, I have to stand back and look at all this odd evidence, and that's just the way I'm going to approach it. It's going to piss. I got more angry messages last night after the show. People don't like it when I do that, but that's how I've done that all my life. When I was a kid playing on the schoolyard, we'd play football or baseball or this and that all the time. Usually I was the quarterback on the losing team, but I was usually the quarterback, one of the main players. And, whenever there's like an argument, oh, I caught that, or I was out of bounds, or this and that, a huge argument when there's no refs, right? It's a schoolyard thing, and it almost comes to a brawl. The argument would go on for several minutes, but then I don't know how I walked into this situation, even though I was one of the main players on the team. The other team would always finally say, Kevin, what happened? And that settled the argument. Whatever I thought that happened, it was. I've always kind of had that way where people just say, "All right, he's not going to lie. He's going to be objective about it." And I even when I played softball years ago for Leitrim's and ran some teams from Leitrim's, the referees would come up to me after a controversial play, and he'd say, "Did I get that right?" They knew I was going to tell them the truth. So sometimes it pisses people off. Sometimes I'm wrong, but I'm always going to say it the way I see it. So let's go back to the hearing. This hearing is fascinating, and everything.
Ms. Roberts, who was in the vehicle, says the exact same thing as Ms. McCabe. And I think one of the other things to note is that these two women, as far as Ms. McCabe and Ms. Roberts, essentially barely know each other at this particular point. So how they are related to this case and how they are related to Mr. O'Keefe is Mr. O'Keefe cared for his niece and his nephew. Now, Ms. Roberts has a son around the same age as Mr. O'Keefe's nephew. They both Ms. Roberts and Mr. O'Keefe grew up in Braintree, knew each other in that regard. Now, Ms. McCabe has a daughter and lived in the general vicinity initially where Mr. O'Keefe lived when he took over care of those children. And his niece is around the same age as one of Ms. McCabe's daughters. Different ages, different genders, different kids. They barely knew each other before this day. And now they're sort of inextricably linked going forward based on their shared experience of being called and told different stories by the defendant on this particular day and taken on this ride along to discover Mr. O'Keefe's body. What I would say, Your Honor, is the revelations from the forensic expert from Mr. Green, which is the only thing even closely approximating new information from the prior Rule 17 motion that was denied in relation to this, they're specious at best. None of that information based on the further, it's similar to the arguments that are made in relation to the facts by counsel. If you take one piece of evidence, you divorce it from context, and you don't provide any sort of contextualization of what that means within the whole of some of its parts. And the same thing is being done as far as the affidavit from the forensic expert is taking this thing and saying, oh, well, there's a search and it's deleted. But if you look at the search and you look at what deleted means, it doesn't mean what counsel says it means. It doesn't mean what counsel purports it to be. And for those reasons, I would ask that the motion be denied.
All right. hear from Mr. Albert's counsel first, and I'm going to let you speak again, Mr. Jackson.
Thank you. So you've heard for 40-something minutes different recitations of facts. I want to focus for a moment for the Rule 17 just on my client and the allegations that the defense has made. Even after you bottle up everything that's been said, the allegation is that someone, not my client, placed a phone call to my client that went unanswered after the body had been discovered in the front of the house. That's the sum total of the allegations from defense that touch on the issue of the phone. The rest of the material that the defense has suggested is relevant to their Rule 17 is theory, and I would argue it's the alternate theory, and they're entitled to make their alternate theory argument. Mr. Jackson, a few moments ago, used the phrase safe harbor in relation to the concept of fishing expedition, and he actually stole the words that I was going to use in relation to the concept of third-party culprit. Because really what that boils down to here is the defense is saying we get to do whatever we want, search high and low, do whatever we need to in order to defend our client. And I understand in concept what that means. But the issue is that under the provisions of our law and the case law, they can't just say it's relevant to their case, snap their fingers, and then go into the personal effects of a third-party innocent person who's related to the case only because they're a witness. But that's the argument that they're making. The only connection between what they're suggesting and my client's phone is an unanswered phone call, unanswered, at 6:23. Counsel made the suggestion that I said earlier that there's never any indication or no record of a phone communication. That's not what I said in my opposition. I said there's no indication of a conversation because there's zero grand jury testimony about it. There's zero forensic evidence about it. There is no conversation because one didn't take place. But that's the suggestion they're using to then bootstrap the rest of the argument. The federal rule 17, the equivalent, is guiding Massachusetts case law. That's been referenced in Lampron.
Just to pause real quick, Dave is on scene. He's sending me pictures, and he's trying to get the link going, so hopefully he should be on any minute. He's in the crowd there. If anybody is at there, look for Dave McGrath. You guys have seen him before on the channel. Go up and say hi.
There's a federal case that came out in 2018. I provided a copy to counsel, and I provided it to the Commonwealth, and I'll hand up a copy to the court. It's, in essence, it's United States versus Cardigan, Alba Delay, 299 F sub 3rd 378. And in this case,
Dave is here, so let me let's bring on Dave. I'm trying to switch. All right, there we go. Dave, we can see you. I don't know if I need to hit a mic for you. Can't hear you. You're looking good though, buddy.
Hey, Kev, can you hear me?
Can you hear us? I can't hear you. So,
I can hear you great. Hold on.
And you're walking the court with them, and you're sitting with them.
mic is not on mute, so on my end. So
Can
you hear me now? How about now? Can you hear me?
I don't know if I should call him, but then he's on that phone. So if you can,
What about
oh, he's going to reconnect. Technical difficulties, ladies and gentlemen. That's the way it goes. I don't have Tom Fleming, our broadcast manager, here live in the studio with me, so this is probably going to be more. Oh, you were able to hear him, Julio? Oh, you probably. That's weird. He disconnected. I don't know why I wouldn't be able to hear it on my end, but. That's so strange. Why could I not hear him? Well.
Hey, Kevin. Hey, Kev, can you hear me? Yeah, can you hear me?
I don't know, Dave. Apparently these guys can hear you and I can't, and I do not have you muted, so I don't know. Hit mic settings.
Hey, what's up, Julio? Can you hear me fine, Kev? Well, for those of you who can hear me, I am outside Norfolk Superior Court right now. Turtle Boy is doing a live rally. Let me turn the camera on for you. And how you doing, guys? Pretty calm scene. Not a lot of agitators. A lot of people grabbing bikes. Hey, and it feels a lot like almost like a people fighting back type of thing against the corrupt institutions that have done this to a young lady here. And it's hot as hell. I forgot to bring a water bottle, of course, so I'm scoping out a store right now. And of course, I dressed in slacks and a t-shirt. I almost always try to look professional wherever I go, just in case. And that was a bad decision today. It is hot. Everybody's sweating. Turtle Boy's doing his little rally right now, and his shirt is drenched. I was going to wear my Karen Reed t-shirt, but I'm trying to be as unbiased as possible. So, yeah, a lot of people here. I'm going to turn the camera around right now. 1 second, guys. I'm just going to turn it around so you can sort of get a bird's eye view. This is the Norfolk County Registry of Deeds right across the street. A lot of people out on the steps right there talking, filming, of course. And hold on, I'm going to try and get up on the steps a little closer to Turtle Boys. You can see the news folks right here. WJAR.
John Beaver was run up their home. It's not okay to kill anyone, but there's a certain unwritten rule when it comes to dead, murdered cops. That the people who did it, they get a little harder. They get a little harder. Instead, it is the opposite.
A lot of people showing up wearing team carrying t-shirts. 1 second, see here. A lot of supporters. There's a picture of John O'Keefe. I'm a picture of John O'Keefe. Hope you guys are getting that. And yeah, it is hot as fuck. Excuse me, ladies. Sorry about that. It is hot. It's hot. And I usually pretty used to the heat. I've spent a lot of time in the Middle East. I hate the cold, but it feels like 90 degrees, and it's a dry kind of heat, so it's brutal. Perhaps I'm dressed a little too overdressed, but whatever. So the hearing starts at 2. I'm gonna hang for as long as I possibly can. I'm gonna get off right now and see if me and Kevin can connect so he can actually hear me, and I'll talk to you guys real soon. Hey, Kev.
Oh, looks like Dave is out. So I couldn't hear a single word of that. I have no idea why. That stinks. But hopefully it was cool. Yeah, it's not muted. It wasn't muted, so I have no idea why it's not coming through. But yeah, you guys, can you hear me, Julio? I'm still here. Somebody give me a shout if they can still hear me. Give me say something in chat if you can still hear me, because I don't really understand.
Hear me? Can you hear me, buddy? No. Something
Thank you,
on
Michelle.
your brother. for the commenters who can hear me, for those of you watching live, it looks like Turtle Boy has stopped talking and like maybe the state police just grabbed him to pull him aside to talk to him about something, because I don't see him now. Or maybe it's a mass court officer is talking right now. I'm trying to get around, but the police are keeping us off the steps, which is understandable. People need to come into court. 1 second. Wild scene here. Absolutely wild. This kind of reminds me a little bit of when I covered the riots of 2020 and 2021 in New York.
I mean, I'll just let him go. You guys can see him. I think the only problem is, for some reason, is I can't hear him on my end. I don't know what else to do.
All right, Turtle Boy's back.
Are they going to arrest Turtle? What's he doing?
I'm going to try and go across the street, give you guys a sort of a bird's eye view, if I can, of what's going on.
That's when the courthouse.
So they're saying we can go into court at 1:30. So I may try and get in that courtroom, shut my phone off and get in that courtroom. So it's a wonderful sign right there. Hi, ma'am. How are you? I'm walking away a little bit now. Is there anybody in the stream who's actually here who wants to connect? Or if there is, happy to see you. Yeah, they're saying we can go into the court at 1:30, so I'm going to jump in there, see if I can get in the hearing. That way I can talk to you guys about it at the end. That'd be cool if I can get in there. Obviously, can't bring my phone in there, so I'm not really sure where I'll put my phone, but wild scene here. I'm trying to give you guys a better eye view. That's kind of what it is right there. Yes, they did be out. 1:30 is what time we're going to be allowed. So I will be in there. I'll let you guys know. So as you can see, there's some signs here. Talk about the state trooper, Michael Proctor. I'm going to try and jump across the street, but I also don't want to interrupt traffic in any way, shape, or form. So that really sucks that we can't connect, me and Kevin, but I'm just trying to give you guys an idea of the scene here. There's a good 200 people, 250 people here right on the courthouse steps. Every car is beeping, and I've yet to see one pro Albert McCabe sign. I've yet to see one person. How you doing? So a lot of people discussing the case. This one here is, I haven't seen a case in years that frankly has drummed up this amount of anger and support for one person, you know? So I think it just goes to show you how distrusting of the system the American people are, you know, and the people of Massachusetts. So how you doing, sir? Yeah, I haven't seen one pro-prosecution person. Although a couple of state troopers in suits walked in, and they were booed heartily. I mean, man, were they booed. That was like Roger Goodell at the Super Bowl type booing. I mean, it was brutal. So I didn't recognize them. I obviously didn't say a word because I have no idea who they are, but it was interesting. Rage Against the Machine, exactly, buddy. The sun is kind of ducked behind the clouds right now. My God, that's the best thing that's happened to me all day. Always peacefully, that's right. We're better than them, right? We don't destroy anything. We don't fight with cops. We obey the law. We just want equal justice for everybody, right? Here's the scene. like right in the street. Sorry, guys.
To raise awareness of this. But more, the person that we are really protesting on, we can talk all day, we can talk about Brian Adams.
1 second.
We can talk about Nolan Adams. We can talk about Michael Murray, and Matt McKay, and we can talk about everyone who is involved in doing that.
Love him or hate him, he's got some balls.
The most protest today is the person who singularly has the ability to end this charade once and for all by them.
I don't know if you guys saw that sign there, but it said question authority, and that's some booing going on. Yeah, not only the signs, Tom, but I mean, just walking up here, I dropped off maybe a half a mile away so I could walk up and stay away from the fray, and every car was just painted with Karen Reed stuff. So every car on the way up here, every single one, even on the highway on 95, you could tell where everybody was going. It was like going to a concert or something. Everybody was getting ready to tailgate. So let's see if I can talk to someone. Hi guys, how are you? Are you from Canton, ma'am?
Well, I'm not from Canton, but I live there now.
Oh yeah? Is that the vibe in the city? Is most people believe Karen Reed's innocent?
It's definitely a division.
Mm-hmm.
There's the select board and the police department and the people who've lived there forever,
Mm-hmm.
and the rest of the town.
Right, sure. That sounds, I hope you guys heard that. That's about as eloquently as I've heard it put. Thank you, ma'am. Hold on. I'm going to get you guys some more signage. You guys like that stuff. DA, stop lying. Hi, ma'am. How are you? Afflicted Michael Conker. Hi, sir. How are you? We got a lady free, Karen. Hi, ma'am. How are you?
But oh yeah, her underling.
This is the best one right here on a poster board.
Also in the courthouse
Hold
right
on.
now in the courthouse.
Sir, can we see that?
A check from all you people, the taxpayers, has decided that he
This
doesn't
other
want
one.
to put it up.
Good.
Why? Because of the wonderful things he does. That is why. That's it. Because it's about. Why is it about?
A lot of justice for Karen.
Because I have
Justice for
power.
Karen t-shirts.
So don't have the power. Well, we're not putting up with that.
A lot of people wearing Justice for Karen hoodies and Justice for Karen muscle shirts. I don't wear muscle shirts because I don't have any muscles. I'm kind of slender, so. How you doing, sir?
And we know that they made out a perfectly valid and reasonable, well-reasoned.
1 second, guys. Just trying to get over if I can here. See here. Arrest the true culprits, justice for John and Karen. How you doing, sir? Good. No, I understand. Actually,
guy standing up there, just ripping, he's smoking it.
I saw that.
Yeah, I was like, I can't do that.
Yeah, I saw that. Are you from Canton?
I'm not from Reading.
Yeah.
Well, Wilmington.
Okay. See here we have defense fund with the what the fuck are these called?
QR code.
QR code to donate to Karen Reed's defense fund.
Doing a fundraiser on the Justice for JJ group.
Justice for JJ.
Yeah.
Fundraiser and the Justice for JJ group.
You donate minimum $5. You get an entry into win a shampoo, conditioner, and a leave-in treatment.
Okay.
I'm drawing it tonight at around 5 o'clock.
Justice for JJ group. There's going to be a drawing tonight at 5 o'clock for those of you who want to donate to a defense fund. You can go get yourself pampered. Even you, Kevin, who you desperately need it. So. Can you guys still hear me? Just give me a thumbs up, guys, if you can hear me. If the commenters can hear me anyway. Yeah, I'm on my iPhone. Have to be. Wow. overwhelmingly support for Karen Reed. And it feels like a parade almost. Feels like a Patriots Super Bowl parade kind of thing. Wow. Incredible. There it is. Hey, I recognize you. What's up, pal? No, I'm not working today. I'm working tonight, so. No, I'm just a concerned citizen.
Okay, guys, I don't know what's going on. It's not the freeze is on his end, obviously, with his phone, so I'm not sure what's going on. All right, let's try this here. He's back. I don't know. It says on my thing can't. It says now. It says his mic is not connected. So I don't think it's on my end now. But yeah. So before when I was having the problem, I couldn't hear him, but his mic was showing as connected. Now it wasn't. Even, now it's saying it wasn't connected. Yeah. I don't know. Well, until his mic, yeah. See, I'm clicking on his mic and it's saying can't unmute your guest. Their mic isn't connected. I don't know what else to do. So we'll keep talking, and as soon as Dave gets some volume, we'll let him go. So. All right, guys, I can't seem to do anything anymore at this point. He's disconnected himself now, so he'll probably just try to reconnect. I mean, I don't know why I couldn't hear the volume before, but then obviously now at this point, he's probably walked into an area where couldn't, and also there's probably a lot of people filming there too, so I'm not sure if he's going through a Wi-Fi signal or a cell signal, but I couldn't hear a word he said, so that sucks. I was looking forward to hearing that. Hopefully we'll get him back on and figure it out. So we still have an hour to go. Oh, let's see, he's here. So
How you doing, Kev? Can you hear me?
Looks like his mic is back for you guys, so hopefully you should be able to hear this. I still can't, but the mic looks solid to me.
All right, guys, we're gonna take Tom, can you hear me? Can everybody hear me? We're going to take one more walk around. All right, great. Thanks, Michelle. Awesome. All right. Is the camera on my face? I'm going to switch it around so you can see everybody here. This is just across the street at the Norfolk Registry of Deeds. A lot of people filming, a lot of people talking. Wild scene here, guys. Wild. Peaceful, very peaceful, but just wild. Take a walk through the crowd. See the free Karen Reed t-shirts. We're gonna get closer up to Turtle Boy if we can.
You know, as a high school teacher for a long time, and I liked my job, and it was satisfying in many ways, but nothing is as satisfying as the work that we're doing right now with innocent factually innocent Reed, and murdered John O'Keefe. That we are out here working with them. Even when the people who were supposed to care about him the most, Paul O'Keefe, abandoned.
I can't get any closer. It's not allowing me to.
I love it. I love it. This is a person charged with murder. We are all here to support her because she's innocent.
I'm gonna try and get up. Hold on.
Factually innocent. Facts back up that Karen Reed had nothing to do with the murder of John O'Keefe. We know that the town of Canton is starting to change. About a year ago, people in Canton were afraid to speak out. You have no idea how many times I heard from people in Canton. They're like, no, I don't want to. It was a culture of fear and a culture of intimidation. A culture where you couldn't even speak out against a murder and a cover-up of that murder for fear of being socially ostracized or God knows what else. Maybe you end up on that lawn next time. That is the culture that used to exist in Canton. That culture no longer exists because we're out here right now and we're doing rolling rallies through the town and we're coming to your home and we're knocking on the door.
Trying to get the best spot. I had to push through 20 people to get this spot.
And every day, more and more people are coming forward. There we go, you love it. Every day I got messages from people in the town of Canton offering me more information. People tell me I used
Definitely a
to be
culture of
afraid.
fear, that's for sure.
But I'm not scared anymore. The boogeyman doesn't have the power that they once did. They can't hurt us anymore. They are the ones who are hiding. A year ago, Joe McCabe was strutting in here. Well, like galloping, but she was strung on in here. Strung on in the courthouse.
Good line.
Every single hearing. Knowing full well what she did. And now she's hiding like the rat that she is. Like the cornered rat that she is. Hey! I've had the pleasure of meeting John and Matt McCabe, John and Matt McCabe, twice now. Luckily they had their shirts on, but I was good. So I had the pleasure of meeting Jen and Matt McCabe. The first time was right on these courthouse stairs, walking down on that sidewalk. And I said to them, hey, you guys are like the material witness in a murder case. You have nothing to hide, right? You're the good guys. You didn't kill anyone. So can you help me out here? I'm just curious. What part of Karen Reed killing John O'Keefe involved you Googling
Close enough.
how long to die in cold? 227. Sure. You're right back.
We gotta clear this area. We have folks coming out of the courthouse.
Okay, so looks like the state police just asked if they could have a word with Turtle Boy, and we are dispersing at this moment. Just give me a minute, guys, and I'll get it figured out. I'm gonna walk away. So here we are. All right, so just to recap, we're in front of Norfolk Superior Court here in High Street in Dedham. Got a lot of Karen Reed supporters. I see nothing for the prosecution. I have not seen one person. How you doing, sir? Yep. I have seen not one person with a pro-Albert McCabe clan sign, shirt, anything. I've seen nothing. So this is a 100% Turtle Boy driven rally. And as you can see, I hope you guys can see this. The state police are now around Turtle Boy. See the troopers there. I'm out here up on the grass right now, which is strictly forbidden. So If I get arrested, please just somebody send me $40 and I'll get right out. Oh, Kearney just came out. Now he's being led away down the stairs. Hold on. Hold on. All right, they're pushing us down. 1 second, guys. Wait one. All right, they're pushing us down. 1 second, guys. It's wild. You know what's funny is I don't see any Dedham police or anything here, which is odd, I guess, for a demonstration this large. But I see a lot of state police here. So, and Aiden's done talking, and here comes some lawyers coming out. There's a lawyer here. How you doing, sir? Yes, now probably going on. So, people filing out of the courthouse. I'm assuming it's some employees taking their lunch break. And yeah, actually, this is an iPhone XR, but I upgraded the camera because I'm a techie. I was doing some research in Montana for my book, and I had this phone at the time, and I was like, this sucks. I can't get any good video. Everything's... So I went in and got a better camera instead of upgrading the phone. So I'm cheap like that. All right, Turtle Boy is just randomly talking to people here. And thanks for buying my book, Michelle. You're going to like it. I promise. There's a lot of work into it. One second.
Very well. I think there's a lot of great people out here, very attractive people. We decided to come out, and we get hot in summer days, and decided to come out here because just and they're out here.
Yes, you can upgrade the camera on the phone. I have the double camera instead of the single now.
What was that? Which two? Hey, sing it, 5-0. Say what's up to 5-0. Is that 5-0 over there too? The girl? No. Why don't you just come across the street if you're going to take pictures? Come on, we see you. Come on, you're not. Come on. Come on. Come on.
I'm not sure what's going on.
Okay. All right.
Yes, I am.
Anyway,
I'm right next to the megaphone, Tom.
I'm really
Literally right
sorry. You
next
don't
to
have to
it.
hold that against me. It's a little hot out here. Oh, thank you. People are just coming through.
Oh, can I grab one from you? Thank you. Can I get one of those? Wonderful young man just gave me a water. Thank you.
At 1:30, they are allowing people to go in the
Yeah,
courtroom.
Tom, I walked away from the megaphone. I'm literally right next to it.
Y'all aren't going to fit in the courtroom, and that's fine. I would actually encourage people to don't come in and watch on Zoom. You can stay outside. That way you'll know when it ends. You can still be here when they come out. So I would encourage people kind of to do it that way. Now, I don't know what time Karen's entourage makes it. Hey! Here they are. Again, that's 5 times. That's 5 laps. Dedication right there. Dedication. Dedication. So, you can watch it online. It's the same thing. You'll know when we come out that way. What else do we need to talk about? What else should we talk about here? So about the Karen, okay. So Karen comes in style usually when Alan Jackson is involved. So, which is I think why they kind of got rid of it. They'll come up in a black SUV, and a whole bunch
Karen
of
should
people
be
will
here
jump out like a
momentarily.
clown car. She'll be one of the last few. And when she comes up these stairs,
Yeah, I don't think he has a permit.
with her four attorneys, Nettie, Elijah Little, and Alan Jackson. And this might be the last time she walks up the stairs with two of them. Well, I think this is her. Because not only are they trying to grab this thing, they are trying to get rid of two of the most effective litigators in Alan Jackson and Liza Little. Up for debate today. They have the option. She has the option, Judge Canelli, to revoke what's called the pro hoc status of the two California attorneys. They are not barred enough to, so when that happens, you have to get vouched for. David Giannetti is vouched for them. And at any moment, the judge can decide to take that away from them. And she clearly, as much as she dislikes me, and she dislikes all of you, and all the people demanding justice, and how much she dislikes Alan Jackson with a burning passion. And in doing so, she hates Karen Reed for hiring her. And ultimately, what she's doing to Alan Jackson isn't hurting him. He'll be fine. It's hurting Karen Reed because Alan is one of the best lawyers in the country. Alan Jackson, especially when it comes to cell phones, he is the reason. He makes people look like fools when they get on the stand, like disgraced WCVB reporter Heather Unruh, who did the same thing Gemma Kay did. Deleted messages and deleted Google searches. And as a result of that, the case for his client, you might have heard it before, got dropped. They don't want that happening this time around. That's why they're trying to, of course, the difference between this case, what happened in the Kevin Spacey trial, and what's happening here, is the Kevin Spacey trial had a fair judge, a non-corrupt judge, who allowed what's called an evidentiary hearing to occur. When two sides dispute something in court, and one person says, my expert says they deleted messages in Google searches, and the other person says, nah, well, that requires an evidentiary hearing to figure out who's telling the truth and who's not. And then we just move on, and we say, and we use that information to go on from there. Well, they canceled the evidentiary hearing.
Okay, guys, the police just told me to get off the stairs. I was a lone person on that staircase, and unfortunately, they told me to bounce. Okay, guys, we have a lot of people here who look like they're just waiting to get to their court appearance. It is hot out here. It's hard to even stare into the sun. I'm going to try and give you guys, get across the street if possible. Get some interviews. Cut through the crowd again. Great sign there. Sorry about that, guys, if you heard that. For some reason, older housewives have a thing for me. They always say dirty things like that, so I apologize. All right, let me turn this around. See, did you hear what she said to me? She was talking about my ass. My God, I'm working here. What's that, ma'am? McGrath. Do I look Jewish? No, I'm Irish Catholic. How about now, you guys getting some pitch back or no? How is it now?
They said somebody from the Metropolitan
The problem is that we have so many microphones here I mean, we got so much going on. It's just, everything's going to be feedback right now. There's a million microphones here. No, I'm just using my iPhone mic. There's a sign here. Justice for Sandra Birchmore, who of course was murdered, and the murder was covered up. Sign here. Who of course was murdered. Just trying to catch some video for you guys of Karen Reed coming in. So you guys hearing that feedback now? Because I'm hearing it here. I mean, it's impossible not to. It's so loud here. Trying to catch some video for you guys. So you guys hearing that feedback now? Because I'm hearing it here. It's so loud. All right, anything else you guys want to see? What do you want me to do? Yeah, it's crazy. I'm hearing it. It's not coming on our end. Is that gone now?
It is, and they had to put down the floor.
I'm away from them as much as I can be, Tom. Should be gone now.
It's hot over there.
I do have an external mic, but of course I didn't bring it today. Yeah, it should be gone now. You know what I was doing? I was standing next to a state police vehicle too, like an idiot, and their radios were... That's really what it was. You'd think I'd understand how to do this by now, but... You know what I was doing? I was standing next to a state police vehicle. I got my thumb over it, Biff. This beautiful young man right here is passing out ginger ale, Sprite, and water for all the people. I got my thumb over it. I paid for it, Tom. Don't you worry. Yes, ma'am. Sure. Let me grab somebody right now. You guys still getting that crazy feedback? Because I can hear it too. Yes or no? Before I ask somebody anything. Seriously, shout out to the beverage guy. Let me grab somebody. Oh, we got a black SUV pulling up. There it is again. I'm trying to stay away from all these police vehicles. There's just so many of them. Just trying to stay away. Hold on, guys. I'm literally walking in the street for you right now, okay? Literally walking in the street for you right now. 1 second. 21. Send you around.
State Trooper Michael Prosecution didn't show up. Show up, he did. And the
There's Turtle Boy there.
3 members of the police department. Lieutenant Gallagher, Lieutenant Lake, Sergeant Good, all put in their report that they found really two things at the scene of the crime that's John's body. They found a couple drops of blood, 6 to be exact, which of course they put in
Yeah, probably. Don't submit to it. Don't submit to the mind control.
No, okay. And
Seems to be no feedback over here, so.
a broken cocktail glass. They found a broken cocktail glass, which they assumed was used to kill John Keith. That was the original plan of the cocktail glass. After Karen Reed found out that she snatched up her car on John's
Crazy scene.
Chevy Traverse, the plan changed. They're like, now we're going to plan B. We're like,
Yeah, the police went away, Tom.
It wasn't believable, but it's slightly believable. Yeah, and let's not forget, if you come across a dead body on your lawn, and there is one shoe on that body, what do you think? Where would be the first place you look for the other shoe? Yeah, maybe inside the house. But they didn't do that. They didn't look inside the house. Because apparently there's nothing suspicious about a dead body with one shoe. Alexis must have done it. Don't you hate when that happens? When Alexis pictures the only brand car where when a shoe is not, your shoe disappears. It just disappears. It's gone. And so did your hat. And they thought nothing was suspicious about the fact that you didn't have a jacket on. This is normal. This is the normal crime scene. It must have been must have been the woman. The woman who doesn't have a criminal record. The woman who has an outstanding reputation.
You guys seeing that? Come around here. This is the west staircase over on the west here of the courthouse. Just stacked with people. Across the street at the Registry of Deeds. Right out here. This is High Street in Dedham, which is sort of a main road here in Dedham, just completely shut down. People everywhere, just a wild scene. Again, I've yet to see one agitator for the prosecution. Not one. Got a lot of people wearing Karen Reed t-shirts.
Seems to be working at the moment, Ma, with no feedback. It's Turtle Boy.
Yeah, it's hot. It's hot, Tom. I'm sweating my ass off.
Now it's back.
And I'm standing in the main entranceway right now, so I could potentially get a video of Karen Reed coming out. That's my main goal for you guys before we close up shop here. I mean, all the way down over to the west staircase now. People sitting here. Yeah, he must be making bank in merch. That noise you're hearing, I don't know if Kevin, if you're running the stream right now, I would ask you to turn it down because I'm going to try and get some interviews and potentially with Turtle Boy here in a minute. Yeah, some folks here. Hold on. I got you. It's hard to avoid that, that's for sure. Ma'am, are you from Canton? No?
Do you want somebody from Canton?
Do I want
Do you
someone?
want to talk to somebody from Canton?
Who's from Canton here?
She is. She is.
Oh, yeah, I'm talking to her already. You're from Canton,
There's a
ma'am?
guy down there.
Come here for a second. I just want to get your,
Yeah, you sit next to her.
I just want to get everyone's theory on the case here. I'm live on YouTube. You're not from Canton? I see you have the Justice for Sandra Birchmore.
That's another case.
Oh, yeah. Oh yeah,
town.
for sure.
And my feeling is that it doesn't matter to me anymore who did what.
Yeah.
You know, they did a crappy investigation.
Sure.
And we have a right to a fair trial in this country. And because they didn't secure the crime scene, they didn't post an officer on the crime scene, I don't think they can take anyone in.
Sure. So do you think this goes to trial or no? You think they'll just throw it out before
Yeah,
trial?
I don't think this goes to trial.
No possible way
I don't
it goes
think
to
it goes to
trial, right?
trial.
What an embarrassment it would be if this went to trial.
I can't see it going to trial. You know, whoever did it. I don't.
Do you know anyone involved in this? Or you just hear a supporter of Karen?
I've been in Canton all my life.
Oh, okay.
So
what's
I mean,
the
I
feeling?
I recognize the names. I would say
What's the feeling in your town? Is it
when
lit
you
or?
get outside the police,
Yeah.
you know, the town, you know, the police and people who've been there forever and back police no matter what.
Right.
Then when you talk to people, I'm usually like, I leave room for it being anything.
Sure.
Most people that I talk to think 100% Karen is innocent. You know, whereas I think, you know, I don't know who did it.
Right.
Yeah, I don't know who did
People
it, but I
beeping
just
again.
know you can't.
What's your YouTube channel?
Yellow Cottage Tales.
Oh my
And,
God, I follow that.
yeah,
That's
yeah.
right.
Oh, they follow you, Kev.
Your jalapeno whiskey.
Who's jalapeno whiskey here?
That's him.
And I'm working on a story for law enforcement today. So covering police corruption. Yes, ma'am.
Oh, and it's a lot. I'm speaking at the
Speaking at the select board. Thank you, ma'am. What's your name?
Thank you. I'm Kathy McCormick.
Very nice to meet you. Dave McGrath. Great to meet you. Stay dry, guys. It's really hot out here. So I tell them what YouTube channel I'm from, and they go, "Oh, we know that channel. I was just watching it the other night." So there you go, Kev. You're famous, bud. Ooh, it's hot. All right, so still kind of on the street here, outside of the fray. You guys trying to stay away from Turtle Boy because that stream is, I think, what's giving us our feedback here. But a lot of police here, a lot of police surrounding. I'm just looking around, and at each corner here, sort of in the distance, there's a lot of officers. So trying to make sure everything stays peaceful here, which it looks like it is. So. Yeah, buzzword is police corruption. That's for sure.
All right.
Hopefully it puts a black mark on the right guys who are doing a good job. Or
That's
go ahead, Kev.
that's me.
Hello. We got people coming down right now.
Outrageous, one of the most outrageous murder trials in history. And this, or at least it was, until a woman named Karen Lee came along. Now she has to pass that to the
Well, I'll definitely ask him, Biff. I'll definitely ask him. I wasn't aware of Karen Reed potentially brother owning electric. Not aware. I wasn't aware of Karen Reed potentially brother owning electric. Not aware. Yeah, a lot of people said they would have been here live and they had to work. Thank God I work tonight. So normally for me, I miss everything too because I have to work. But this just so happened that a lot of people said they would have been here live and they had to work. And here's the team. For me, I miss That's the scene. Yeah, I probably won't ask him that, Tom. But it bears asking. Every question bears asking, right? But I believe if you followed him, his live shows, he was waffling on what kind of car to get, right? And he was going around on a couple different models, so whatever that's worth. Hi, ma'am. Hi, ma'am. How are you? All right, cutting around the street now. I'm sort of outside the pack here.
We're not going anywhere.
There it is. I get it, Biff. Here comes the Boston Police detectives. How about that scene? That was Boston Police Detective Carl Dugal. No, that was Carl Dugal, Boston Police Detective, and he's written a lot of pro-prosecution things. Okay. Thanks, Tom. If you guys don't know, that was Boston Police Detective Carl Dugal, who's wrote a lot of pro-prosecution things online, and believes that Karen Reed absolutely murdered John O'Keefe, and believes the prosecution. So he just got booed out of the building. So. One second.
Last time, the people of Boston are unsafe to send enough morons onto the roads every day. Kyle showed up because he's that arrogant. He's that much of a loser. He doesn't care. He knows what you're all thinking. He knows the truth. But all that Carl Dugal, that's the only person who actually is dumb enough to believe that Karen Reed is. He's in the belief system. So guys around the time, oh, Karen didn't call me the next day and see how my feelings were because my
The audio seems to be best right here, so I'm going to stay right here, guys.
You didn't call her either. You never asked her how she's doing. My friend was to watch the audio seems to be best right here, so I'm going to stay right here, guys. A lot more than you ever did, you fraudulent, fake, bastard detective. That's what you are. You're a disgrace. I haven't seen a single Michael Chestnut when his family walked into his courthouse, they were supported by dozens of officers from the wing. Michael Chestnut, when he walked into all his positions, their courthouse, their phones, brothers. Where are the Boston Police uniform? Nowhere. You know why? They know that we know that John O'Keefe was murdered by one of their own. And his lawyer entitled Bill son my nephew, and that Karen Reed sure as shit didn't do it. That tells you everything. The Boston Police have nothing to do with this charade. It's all you need to know, except for that moron and his stupid wife, who had a really good mouth. Until I started asking questions. Then they didn't have much to say, did they? They didn't have much to say. They were big comeback. They were a big comeback to Karen. They didn't have much to say to me, though. I wonder how that is. I wonder why that is.
Gonna get closer.
And I truly believe that you could shut me up. If I truly believe Karen Reed did this, you wouldn't be able to shut me up. I'm like, you want to talk about it? Well, let's talk about all the evidence. Let's do it. But guess what?
Can you guys hear okay? Give me a thumbs up.
They got nothing. All they got is a pile of crap pointing back to to Michael Foster, Ryan Egan, Ryan Albert, Colin Albert, Matt McCabe, Jim McCabe, and every single other person in that house who remained silent to this day, despite knowing that a Boston police officer was murdered on their watch. And not just murdered, badly beaten on their watch. And any one of them, including Nurse Sarah Levinson, could have saved his life. Could have tried. Could have done something. But did they? No. Instead, they Googled how long to die in cold, and they waited and counted down the minutes and just waited for that poor man to expire and die from hypothermia.
No problem.
They knew that. They are cold-blooded killers, and they walk amongst us. No one is safe as long as they are out there. And these people in here have the ability to stop it. It is up to them to do something about it. We know Adam Holly can't do it either. We know that Colombo Morris did. He is not going to do it. He's probably drinking and driving right now like he was in 2013. Yeah! Free Karen!
Mob scene here, guys. How's it now? Pretty good? I mean, I'm not that. Just gonna put my water bottle down real quick. How's it now? Pretty good? People right here at the corner, right across from the Unitarian Universalist Church. State Police over on the side. How you doing, sir? Good. People right here at the corner, right across from the Unitarian Universalist Church. Police over on the side. How you doing, sir? Good. People right here. Look at this. Look at this. Look at this. Oh, thanks. Thank you. Thank you, ma'am. I feel fine, yeah. Yeah, I feel good. Thank you. Hope you guys are seeing this. You guys see that? How cool is that? I did see your dog. Even the dogs agree. Even the dogs agree. Of course. Even the dogs agree. Even the dogs agree. How's the feedback now? Basically gone?
We are about, what time is it right now? 1:35-ish?
138.
No. It's John's parents. We're not doing that.
John O'Keefe's parents just walked through.
Personally, probably my son, John, so I give a shit a little more. But look at
John O'Keefe's parents just walked
so,
through.
but we're not going to do that. We're not going to move. Yeah, because they'll come around. They've been lied to. They've been manipulated. Someone's the victim. Because we're choosing not to.
Yes, he dumped and ran. Yes.
I forgot this part. It's good about that. That's how we're here to protest. Hopefully one day they come around. Today, we're sitting on the side of this. We're actually go to jail. So just a reminder, guys, really limited seating in the courtroom. You're probably not going to get fired. And that's fine. You can soon the new code has to run something down. I mentioned there's going to be multiple media outlets in there live streaming it.
Okay, Turtle Boy's been called in. Turtle Boy is now inside the courthouse. You notice that the feedback went away because no more megaphone. Turtle Boy has been called inside the courthouse, so see what happens here. Everybody still with me or what? Oh, Lord. Big scene out here today, guys. How you doing, guys? Good, good, thank you. All right. Just to recap, we're out front of Norfolk County Courthouse, Superior Court, 650 High Street in Dedham. Crazy scene here. I gotta say, it's probably swelled to about 300 people now. Maybe 100 across the street, 100 or so. And the Turtle Boy's gonna talk. Hold on. Karen Reed is about to arrive, guys. Karen Reed about to arrive. I just want to get you guys that video, and then we'll end. All right. Let me go up on the courthouse stairs. Get a little closer for you guys. Best I can here. Yeah. It is hot. It is hot. Second.
No. I'm going to leave it right here. Thank you.
Hey guys, we'll be showing the hearing live. I'm not sure. Dave might be getting a little freeze or just getting too close to stuff. I'm not sure, but the hearing. So Tom says that Turtle Boy ended his to go inside. Looks like Dave is. Oh, Dave is back. All right. Not sure why we can't hear him. The mic is good. Not sure why we can't hear him. The mic is good. Okay, he's going to reset, guys. Sometimes you have to do that. I didn't mute Dave. His mic was showing open on my end, so I didn't mute him. But all right, guys. So the hearing will be starting in 15 minutes, and we're going to broadcast it here. So I'm pretty sure it's going to be on WCVB TV, Channel 5. That's how the other hearings have been. It'll probably be on Court TV too. I have both of them set up, and I'll stream whichever one seems to get on first. I'll put them in here. So interesting. Doesn't seem like there was any support there for the other side. It was all Turtle Boys rally. Oh, Dave is trying to come back in.
Kev, what's up, buddy? Say something.
Can't quite connect to him, guys.
1 minute.
All right. So, there he is.
What's up, Kevin? Can you hear me at all? Can't hear me. Guys, for those of you who can hear me, Karen Reed is about to come in to the courthouse. Turtle Boy just went inside. I was able to run right up next to him and film him the whole way in. I don't know if you guys got that or not. Then the state police told me to bounce. So there's a woman here handing out ring pops and Tootsie Pops of however many licks to get to the bottom, and then ring pops with show us the ring footage. So very interesting. The hearing is about to begin any minute. Karen Reed's going to arrive. It's now 13:47 and it begins, I believe, at 1400. So I'm going to stay with you guys until then. Maybe we can get a video of Karen Reed getting out of the car. That's really all I want to get for you guys. So give me a minute for Karen Reed to arrive, and I'll get that video for you, and then I'll sign off while the hearing goes on. So that's that. Norfolk County Courthouse again, 650 High Street, Dedham. Karen Reed hearing, 2 o'clock. Turtle Boy has gone inside, but there's still a ton of people just hanging out, waiting. So, and it's hot, man. I don't know how hot it is where you guys are today. Tom, it's probably 100 degrees in North Carolina, though, huh? So. Turtle just went in, gave a rousing speech for about an hour and a half since I got here. Carl Dugall, the Boston police officer, detective, who has been writing a lot of pro-prosecution stuff on the internet, walked through. He got his ass sued in ratio to 6 ways to Sunday here. He's with his wife and another man. Still waiting on Karen Reed, though. It's 1:48, so I'm still... should have been here by now, but who knows, so bear with me. A lot of people discussing the case outside on the courthouse lawn. It's like the world's biggest true crime podcast. And 263 people total in the chat, so that's got to be some kind of record, eh, Kev? And somebody, and Kevin, you may have a cell phone close to your laptop. Maybe, I don't know. So Comes Karen. Here comes Karen. Roll up on that.
Free Karen Reed! 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 Free Karen Reed!
Okay, guys.
Free Karen Reed! Free Karen Reed! Free Karen Reed!
All right, so there's Karen. She had a big smile. That was awesome. That was awesome. She had a huge smile. She gave the crowd a thumbs up. Her defense attorney, also Alan Jackson, gave a thumbs up in her team. So there she is. Any minute this is going to start. All right, guys. So I'm going to go charge my phone, grab a drink, and try and go live again after this thing ends. Maybe we'll try and catch up with Turtle Boy at the end of this whole thing. One of you guys give me a call or a text when it's all over. Because I'm going to run to the store, grab some drinks for everybody here. It looks like a lot of people are thirsty and sweating their asses off. So I'm going to sign off for now. Thanks so much for watching, and thanks so much for having an interest. And we'll talk real soon, guys. And yeah, Jen McCabe was a no-show. Jen McCabe was a no-show. All right, guys. You can also stream it. It looks like on it looks on CBB. My wife's telling me. So I'll talk to you guys soon. We'll do this again here in about an hour or so, depending on how long the hearing is. So I'll talk to you guys. Thanks, guys.
Oh, I guess Dave is out. We can still hear him though. I hear something. Oh, that's on my phone. Sorry about that. Okay, guys. So the hearing should be starting soon. We're going to hear it as soon as I can figure out the best place that it is hearing. The last time it was on Channel 5 WCVB. I'm assuming Court TV is going to have it on too. If somebody else finds it on another channel quicker, I'll go into it right away. I'm watching them continuously to see which one comes on first. That was really exciting to watch. Dave did a fantastic job. I'm sorry about the feedback. I don't know what we could do because there's all these devices there and they're all listening to each other and listening to Turtle Boy. And so you get this loop going on. Maybe there was a way to do that without, I don't know of a way to do it without the feedback. But that was really exciting. You're welcome, guys. That's obviously not the Turtle Boy we know because he was speaking there, but must be an assistant. Let's see what we're checking through the comments. So Biff, I was waiting 2 hours and got kicked out. I'm not sure who that is. Pap Smear, you're welcome. So we got about 6 minutes, and then we'll get right into the hearing. Oh, TB admin there. All right, guys. So are you guys still Turtle Boy admin? Are you guys still, what are you showing on your channel at the moment? I wanted to put it on. I was even tempted to share it here, but I didn't know that would cause a problem too. So, because we can split the screen up. But 6 minutes until the trial. This is many ways looking like, we noticed this at the beginning, all of us here looking at this, the trial of the century. It's going to, I mean, you've heard that expression many times before, but this one is going to be eligible. So I started getting texts from different law enforcement people way back in April saying, go to this website, TB Daily News. There's this huge breaking story. And these guys are saying this is going to be it. This is going to be the big story of our lives for the next several years. So that was really my first exposure to Turtle Boy. I had heard of him. Tom Fleming, one of our managers here, has been a fan, and other people. I just hadn't gone to his site. He's from Worcester, which is where I owned a bar for a lot of years. And apparently we were talking together. I was on his show last Saturday, and he was saying, well, I was in your bar, so we must know each other a little bit. So let me just check in here, and now we can. All right, so hopefully you guys can hear me. If anybody can't hear me, please let me know right now, because technology is obviously... yes, we are showing the hearing. So if anybody can't hear me, please let me know. As soon as we find where the hearing is, Channel 5 usually pops on they'll pop it on right as the hearing starts. So if somebody finds a link sooner, let me know. I also have standby on Court TV. But someone will, if it's not on Court TV or Channel 5, it'll be on something, and someone will tell me, and I'll put it right up on the stream. And you won't miss anything, because it's going to take several minutes for the whole thing to get going, and there's kind of a proceeding thing that goes on. 508 loves 420. 508. I for many years had a 508 phone. So thank you, Tom. The volume is still good. So we have T-minus 4 minutes. I'm sure it won't start right away, but I think they want to get this hearing going. Zoom hearing is at max capacity. It's going to be on TV. I mean, this is a bigger hearing than the one in May, and the one in May was on Channel 5. So it's definitely going to be on, and we'll switch over as soon as it'll only take me 3 seconds to switch over. But if someone finds it quicker, let me know. Let's keep an eye out for that. So anyways, and I promise during the hearing, I won't say anything. So I'll probably make myself another fluffernutter sandwich. But we'll be here as soon as there's a break, and we'll talk about it. Meanwhile, you guys can be commenting in chat, though, because every one of these hearings, there's interesting things that come out that nobody was expecting from both sides. And also, it's going to be very fascinating to see what the judge, it's there. What do you mean, Steve? Court TV? See, is it on Court TV? Let's see. Should we just go live to Court TV? Go live, and let's see if it's on. Oh, I can't go live for some reason. So let's keep checking Channel 5. I also have Channel 5 on the TV. So has anybody found the stream yet? We'll link to it as soon as we find it. Hillary's going to have a sandwich too. WBZ, okay. All right, let's go to WBZ TV. That was actually, believe it or not, strangely enough, my mother that told me that. She's watching. I don't see it here though. Let's see. Watch live. Okay, it'll be coming on in a second. All righty then. We'll have you guys streaming set up in 1 second.
Now on WBZ TV and
This should be it,
streaming on
guys.
CBS News Boston. This is WBZ News.
Breaking news here at noon. After 19 seasons with the Boston Bruins, Patrice Bergeron is retiring. Good afternoon. Thanks for being with us. I'm Paula Evan. Bergeron's announcement came just a day after his 38th birthday and it ends a remarkable career. In 2003, the Bruins drafted Bergeron in the second round, and he never played a minute with any other team. Bergeron helped lead the Bees to a Stanley Cup in 2011, and he ranks third in Bruins history in games played. He spent his final 3 seasons with the Bruins as their captain. In a statement, Bergeron wrote, "For the last 20 years, I have been able to live my dream every day. I have had the honor of playing in front of the best fans in the world, wearing the Bruins uniform and representing my country at the highest levels of international play. But after listening to my body and talking with my family, I know in my heart that this is the right
I
time
can't
to
copy that
step
link, so you're
away
gonna have to
from
send it to me
playing
on my
the
phone.
game I love."
Or
Just minutes ago,
email it
I
to
spoke
me.
with WBZ's Dan
Or
Roach
Facebook.
about Bergeron's legacy.
Won't let me
It's
copy
kind of a
out of
mixed
chat.
emotions day, Paula. When you look at Patrice Bergeron, his body of work, came in as an 18-year-old kid and has been with the Bruins basically for 20 years. He's the heart and soul of that organization, captain, has done everything you want to do in a Bruins uniform, that you want from him, and as a fan, that you want to watch as well. So mixed emotions from the sense of sad to see him no longer playing hockey, but happy that he was here his entire career and turned 38 on yesterday. So, it was time for him. He wanted to settle in with his family, but man, what a legacy. What a career, one of the best to ever do it. Probably a top 5 Bruin with the names of Orr and Raymond Bourque and Chara and company. So he's certainly an elite company, as one of the greatest Bruins of all time.
Certainly is. We will have more on Bergeron's retirement and reaction on WBZ News beginning at 5. And Bergeron plans to speak with the media, by the way, tomorrow. We also have breaking news from the Celtics. Jaylen Brown has reportedly just scored the richest contract in NBA history. The Athletic and ESPN are reporting that Brown and the team agreed on a new 5-year deal. It's worth $304 million. Last season, Brown averaged more than 26 points per game and shot nearly 50%. He has been with the Celtics since 2016. This new deal has him with the Celtics through the 2028-29 season. And more breaking news from the sports world. LeBron James's son, Bronny, is in the hospital after suffering a cardiac arrest. Yesterday, the 18-year-old was at practice at USC when he had a medical emergency. James is now out of the ICU, listed in stable condition. The incoming freshman was one of the top high school prospects in the country. Now to next weather on this Tuesday, another hot one, and we could see some storms later on this afternoon before the heat wave arrives. Taking a look at sun on Boston Common, let's bring Zach Green in with a look at our next weather forecast. This summer, Zach, we never know what happens next.
Exactly, kind of a roller coaster over the next few days. As of now, still the calm before some storms ultimately arrive. It's not going to be a ton of activity, but you notice there's a real strong batch of thunderstorms just to the south of Williamsport, Pennsylvania. This is the same round that's progressively going to be moving east and sparking off the isolated showers here locally. Again, not for everyone, but we do see this. Heavy rainfall rates seem to be the main topic. We're unfortunately going to likely lead to some localized street flooding. Shouldn't be all that long lasting, but it is pretty hard hit once it does arrive. Some small hail going to be possible. A lot of wind just up over our heads, starting to generate some of that possibility. But with the heavy rainfall, it also drags down some of those higher wind speeds towards the surface. So gusty straight line wind damage is also on the menu. You hear a rumble of thunder, make sure we head indoors just to be safe. Not all that long lasting, but it still could be affecting us as we go into the second half of the day, about 3 p.m. and onwards.
So it sounds
we
like
all turn our eyes to the heat wave, Paula.
Yeah.
90s, Wednesday, Thursday, and Friday. We'll
waiting.
let you know about the excessive concern at the end of the week in just a bit.
Whew, gonna get the AC going. All right, Zach, thanks. Breaking news, Republican presidential candidate Ron DeSantis was involved in a car crash this morning. The governor of Florida was on his way to a campaign event in Tennessee when police say traffic slowed and 4 cars in the DeSantis motorcade crashed into each other. The campaign says neither DeSantis nor any members of his team were injured. More breaking news. Teamsters say they have reached a tentative deal with UPS, which could avoid a strike. The Teamsters say the agreement includes higher wages and air conditioning in delivery trucks. Union members will start voting August 3rd. This afternoon, 2 men are being treated for severe burns after an explosion in the basement of a Holliston home. As WBZ's Nick Giovanni shows us, first responders say last week's strong thunderstorms are partially responsible.
It's awful. It's tragic.
What's going through your heart and mind right now?
An explosion rattling a small community in Holliston.
But it was scary. I was scared and I was worried for them.
Kristen Mahoney was home when she heard the explosion Monday afternoon, ran outside to find her neighbor and another man badly hurt coming from this home on Westfield Drive.
I saw my neighbor running out and he was yelling, call 911.
According to the fire chief, the homeowner and an electrician were trying to troubleshoot the boiler.
Okay, guys, hold on 1 second. That's it. We found it. So give me 1 second. Come on, Jesus.
Hold on 1 second. Is everybody coming in now, Jim?
Old fucking round bitch.
Please turn off.
All right, Jimmy, I am ready.
First matter is the Robert Berry case, 18244. It's with Mr. Lally and Mr.
Shut your camera off.
Ms. McGrath, you can stay there.
Please turn off your microphone.
It's not open yet. Oh, maybe they were on break.
Mr. Clerk, can you mute everybody?
I didn't. I'm muted, so.
Counsel?
Adam Lally for the Commonwealth. Good afternoon.
Good afternoon, Mr. Lally.
Good afternoon, Your Honor. Sean Riley for the Commonwealth.
Good afternoon, Mr. Riley. So this is on
Yes, Your Honor. Last time we were before the court, we had discussed a possible resolution also, as well as some next possible trial dates. We had discussed an August 7th date and a November 7th date.
Yes.
We checked with each of the respective witnesses, and there was one necessary police witness, a constructionist to be specific, who unfortunately suffered from a recent medical episode and would not be available for that August 7th date.
Okay.
I did speak with counsel, Mr. Reddington's office, in regard to that 11/7 date, and I believe
Reddington unavailable today?
he is currently on trial in the Fall River Superior Court. But I did speak with his office and indicated to them that I would be expressing to the court that both myself and counsel were available for that 11/7 date, if it's still available for the court. We'll also discuss a final pretrial date of October 25th.
October what?
25th.
I don't think I'm available, Jane. I'm not available that week.
The week of the final pretrial, Your Honor?
Yes. Yeah, I'm available for the trial. Your office will have to move it.
I know, but I was hoping to watch it, okay? Very interested in the case. Pretend it's Facebook. Yeah. Imagine if you couldn't go on Facebook all day, you fucking have a heart attack and die.
Online, or otherwise everyone's going to be on.
Good.
All right, so we'll talk to Mr. Reddington, get a date. I'm out the last 2 weeks in October.
Okay, so I'm on trial the last week of October, so I'll look for something the week before.
Okay. All right. Thank you.
Thank you, Your Honor. Thank you, Mr. Clerk.
Thank you. Judge, next is docket number 2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Again, Adam, I'll take Commonwealth again.
Good afternoon again, Mr.
You are unmuted.
Good afternoon, Ms. McGrath.
Good afternoon, Your Honor. Attorney David Yannetti and Attorney Ian Henchy from the Yannetti Law Firm on behalf of Karen Reed.
Good afternoon, Mr. Yannetti. Good afternoon, Mr. Henchy.
Good afternoon, Your Honor. Elizabeth Little from Merkston Jackson and Quinn LLP, also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon, Mr. Jackson. Good afternoon, Ms. Reed. All right. So, Mr. Jackson, I think I will hear you on your motion to recuse.
Your Honor, if I may, and thank you for that. There are several matters on calendar. I just want to make sure that we're on the same page in terms of the order in which we address things. So the first thing I'll be addressing is the recusal motion that we filed that's currently impounded. Ms. Little, if the court, depending upon how the court rules on the recusal motion, that will perhaps beget additional discussion about some housekeeping matters. There's about 4 motions that are on calendar, some of which the Commonwealth has filed, including a motion to compel, our opposition to a motion to disclose the name of an investigator. The Commonwealth.
I haven't seen that motion.
You haven't seen that, the one dealing with, it's the court probably is thinking of it in terms of the animal control motion. There was a request by the Commonwealth that they be given access to the animal control documents, but at the same time, they requested the disclosure of our expert or experts that may review those.
And will.
All right, I know. All right. So we'll have to hold that motion, Mr. Clerk. Right. What are the others that you think are on the calendar for today?
I think the court will probably want to address the Commonwealth's motion for timely protocol, which was advanced a couple of days ago. We just got notice of it, I think, 2 days ago, 3 days ago.
But
it may have been yesterday.
But I think what happened with that is Ms. Little had filed a privilege log. So
That's
she
correct.
filed a privilege log, and so
It makes it moot.
Yeah, so with that, we're ready to move forward with the protocol. So
Okay.
that doesn't need to be heard, and I'm not sure your other one does, but I'll have Mr. Clerk pull it. What else do you think should be heard today?
The only other thing is the Commonwealth's request for a gavel.
Yeah, so I think there's really just 2 motions on. So
Right. I'll address
go ahead, Mr. Jackson.
With the court's motion, I'll address the recusal motion issue, and Mr. Yannetti, my colleague, will address the gavel motion.
Okay, go ahead.
Your Honor, to set a baseline for discussion about a motion of this nature. I think we had to go back to some predicate rules in court and predicate rules in the justice system. The cornerstone of a just and an equitable system lies in the belief that every single individual that appears before the court has the same right to a fair trial. Chief among those rights enshrined in the Constitution here in Massachusetts and the Constitution in the United States is the impartiality and the neutrality of the judiciary. That's why we're here today. Anything less than that, and the system is rendered completely iniquitous. It's morally broken. But fairness and impartiality by the court is not enough. In other words, the court can't simply aver that it's fair, that it's unbiased after doing some soul searching. That simply won't do under the current law in Massachusetts and the current law in the United States. For a motion of this sort, it's not our burden to establish that this court is actually biased or actually partial in some way, and we are not making that argument. I want to be very clear about that. Rather, the Code of Judicial Ethics mandates disqualification of any jurist in any proceeding in which either the judge cannot be impartial or the judge's impartiality might reasonably be questioned by a member of the public. In other words, or in the words of the appeals court, quote, actual impartiality alone is not enough. Our decisions and those of the Supreme Judicial Court have commented often and in a variety of contexts on the importance of maintaining not only fairness, but also the appearance of fairness in every judicial proceeding. And it's that latter point or that latter rule that brings us to court today. We have, through our motion practice, presented facts and circumstances that would and have given reasonable, disinterested members of the public a basis to doubt this court's fairness and doubt this court's impartiality. Again, that does not mean, and we are not stating or averring, that this court is not fair or impartial. Only the court knows the answer to that question. But the facts we've presented unquestionably are such that the public might, and that's the key word, the public might doubt the court's fairness in some regard. And that's all that's required for this court to do the right thing and step aside from this case. Those facts which we have averred, which we've presented, all of which are public, it's not anything that we've supplied to the court which isn't already in the public discourse, include the following things. Number one, the court's, at this point, pretty routine practice of not ruling on important defense motions in a timely fashion. We have a motion before the court currently that I believe, if I counted correctly, as of today is 87 days old, and the court has not ruled on that motion. That's an important motion for us. It's a motion to compel, and it deals with physical evidence. But it still has, the court still has yet to rule. That is, in no small part, patently detrimental to the defense, to our moving forward with the defense case and our preparation. And it's a predicate of a fair judiciary, that decisions are made promptly and without any undue delay. That's contrasted, Your Honor, against the court regularly, apparently, ruling on motions that directly benefit the Commonwealth. Like when the court immediately ruled from the bench and granted 2 motions to quash subpoenas that favored Ryan Albert and Jennifer McCabe. For those records, there was no delay. For that request, there was a series of requests.
Hold on a second.
Please turn off your audio.
Go ahead, Mr. Jackson.
Best laid plans, right? For the request that I just mentioned about the quashal motions, there was no delay by this court. The court made the rulings from the bench, and that made the public, in public commentary, question the court's motives. In fact, the court has unilaterally sought to even advance certain motions that the Commonwealth has presented. May I?
Try again. Sure.
The court has unilaterally sought to advance motions that have been advanced by the Commonwealth while still not ruling on motions that we've had before the bench for not just days or weeks, but now months. And it's the disparity in that treatment. Look, I don't disregard the fact that the court is a very busy court, that the court is a supervising court. The court has a lot of balls in the air. It's the disparity between the court's rulings in terms of the Commonwealth's motions and the defense motions that I think give the public pause, and that's where we need to start our analysis. Number two, the court seems to have deviated from the normal course of procedure, in this case, in order to specifically stay on the Karen Reed case. And the court only made that known, or at least known to us, to the defense, after the Commonwealth filed a request to gag the defense. The optic is that the court had or has a personal interest in ruling on that particular gag motion, which is on calendar today, and wants to keep control over this case. That move has also prompted the public to raise questions about the court's fairness. Why is that happening? And it has eroded public confidence in the system, at least insofar as this case is concerned. Number three, the court outright denied Ms. Reed a full and fair opportunity to be heard, if the court recalls, the last time we were here on a critical Rule 17 motion. And that motion was from records, importantly, from the very same family that now claims to have a personal interest and a personal relationship with this court. Troublesome allegations, troublesome claims by the family at the very least. And that brings me to the final point and dovetails into that final point. Sean McCabe, a member of the McCabe family and a brother-in-law of Jennifer McCabe, whom we have argued in this court, should have at least been a suspect.
You're going to show that this way, Ms. Little. Why don't you show it to me? Thank you.
Sean McCabe made a claim to a reporter in public, claiming to have a personal relationship with this court. And he tried to prove it by citing to the fact that Sean McCabe knows personal information about the judge, which is extremely troubling, about a beach home, not just the fact that the court may own one, but exactly where it is. His words were, after receiving Sean McCabe's words were, after receiving a question from the reporter, do you really have a line to Judge Cannoni? His answer was, Auntie Bev, and I mean no disrespect, I'm quoting, Auntie Bev, whose seaside cottage do you think we're going to bury your corpse under? Extremely troublesome dialogue, but it's not just the threat that's inherent in the dialogue. That's on one level. It's the fact that this person claimed to know that this court may own a beachside cottage somewhere. Your Honor, I will say I've appeared before hundreds. At this point, I'm getting old. I may have appeared before thousands of judges in my nearly 30-year career. I've never, ever known where a single one of them has ever lived or property that they may or may not have owned. But Sean McCabe appears to know, and he appears to intimate that he knows the details of this court's personal life. And it was his family that benefited by the cancellation of the evidentiary hearing, and it was his family that benefited from the court's quashal of our subpoenas. That claim by a McCabe family member of a personal connection to this court has been the fodder, Your Honor, of myriad public comments and questions about this court's ability to maintain fairness over this particular proceeding. And if that weren't enough, the defense has just recently received information that another witness, a similar witness for the prosecution, by the name of Julie Nagel, who was Julie Nagel, N-A-G-E-L, who was inside the house at 34 Fairview on the night of John O'Keefe's death, apparently some 5 months after John's murder, and this is all public. We didn't have to do any digging and searching with subpoenas or otherwise. This was all public information. She used a Venmo app to pay for what appears to be a beach house rental, and the recipient on the Venmo payment reads Frank and Beverly. That is a public payment. It was there for all the world to see. And as soon as a reporter picked up on that, which is how we found out about it, and publicized that, she immediately took that payment down and took it off the internet. Obviously, I have no indication whatsoever, and I do not stand before this court suggesting that there's a connection. What
I can't see that one, Ms. Little.
This is simply a screenshot.
Could you bring it closer? I have not seen the previous one, Ms. Little, just hold up. I know you put the other one with your.
What you're looking at is a screenshot of her having taken down that Venmo payment after it became publicized, which obviously looks somewhat suspicious on her part. These are all instances that have been the subject of public discourse, not just the defense team sitting in a room pontificating. Every single one of these instances has been something that has been in the public discourse. And the public is questioning this court's ability to maintain fairness given the panoply of information that is now before it, all in public documents that we happen to be privy to because we're part of the public as well. Nothing that we had to do any deep searching for. Your Honor, there has been an undeniable erosion of public confidence in this court's ability to be fair. But let me be very, very clear. The decision to recuse or disqualify a court due to the appearance of impartiality is not an indictment of this court's competence or integrity. It is not an indictment of this court's character. Nowhere close, and we do not aver that at all. Rather, the decision should be an expression of the unwavering commitment that this court has to justice, to fairness, to the rule of law. That's all. By taking this principled stance, the court will be safeguarding the core tenets of our justice system. Actual impartiality is not enough to deny this motion. If there's even an appearance of partiality, this court, according to the law and to the rules of judicial ethics, must grant this motion and disqualify herself. We simply ask the court not to let this perception cast a dark shadow on the scales of justice and over Karen Reed's right to a fair trial. I'll submit.
Okay. Does the Commonwealth want to be heard?
Just briefly, Your Honor. Again, just briefly, as far as this court's impartiality, I personally do not, nor have I ever even had a question in my mind as far as the court's ability to remain fair and impartial in this or any other case. As it pertains to the standards.
I don't think they can hear you.
I so apologize.
No, I saw your client and I interrupted Mr. Lally.
Is it possible that he could address the court from the podium?
Yes.
Your Honor, let me start again, and then first I just want to impart that I personally do not, nor have I ever had any questions, even a moment of pause in regard to this court's ability to be fair and impartial on this or any other case. As the court is well aware and was recently reiterated by the appeals court, the Mitchell case, there's two prongs as it applies to this. First, as counsel alluded to, the subjective determination by a judge believing that they can be impartial. And secondly, an objective appraisal of whether this is a proceeding in which the court's impartiality might reasonably be questioned. And I think the operative word there is reasonable. The support of the motion, and let me be clear that whether the court, Your Honor, chooses to retain jurisdiction of this case, or it passes to another judge to retain jurisdiction of this case, or it passes from judge to judge as the judges rotate in and out of the session, really is of no consequence to the Commonwealth. But what I would say is that, again, that operative term being reasonable, and the three sort of key things the council seems to want to hang their hat on is essentially the first being some conversation between two individuals who have literally nothing to do with this case, who talk about this case in an online discussion. And there's a great many things that are said in that online discussion, but we seem to be focusing on just this one thing and accepting this is true because this is what this person said. Whereas there are a great number of other sort of defamatory things that are said by this person, Mr. McCabe, in reference to this blogger. And we're not jumping to the conclusion that any of those things are true. I don't know whether they are or they aren't, but I'm just saying that we're focusing in on this one particular thing. From that attachment the council filed as far as that conversation, which is appeared to be a true and accurate copy of that conversation, but it's not appeared to be a complete transaction of that conversation. But from what's attached, direct the court's attention to page 6, in which Mr. McCabe intimates in there that he doesn't really know anything about the case.
Okay.
Additionally, I would direct the court's attention to page 9, where I think it's pretty clear from there that the recipient of these communications, this blogger, doesn't even believe Mr. McCabe himself in his veheemence that he knows the court or is familiar with the court or has any influence over the court. And lastly, from that attachment, I direct the court's attention to page 11, in which it references earlier posts by this blogger about the judge. And that's, again, I think we're looking at this divorced from the context in which this communication arises. This is not something that Mr. McCabe just generates out of his own head, as far as, along with a litany of other assertions that he makes in reference to this blogger, but it comes from prior posts and prior communications that were expressed by this blogger of already intimating impartiality by the court, just in reference to adverse rulings, which brings me to my second sort of underpinning of this motion, being that the court has, I guess, adversely ruled or denied motions that were filed by the defendant. I don't really see that as being any sort of valid basis for a judge to recuse themselves. Otherwise, every time a judge denies a motion, then we're going to have to find a different judge because they don't agree with you. And in particular, they're pointing to a motion which had absolutely no basis in the rules of criminal procedure whatsoever, as far as having an evidentiary hearing on a Rule 17 motion. And the third thing, as far as deviation from procedure of the Norfolk Superior Court, there are a number of cases that different judges might hold on to for a period of time. They might assign themselves to or be assigned to retain jurisdiction. And the court, hearing this motion or any other motions in this case going forward, regardless of whatever session Your Honor is assigned to, it's really of no consequence, and it's really not anything that's out of the ordinary, as evidenced by the case that was called prior to this case, which is a trial that was conducted before Your Honor last November of a co-defendant. There's a scheduled trial date coming up in this November of the co-defendant from that prior trial. It's not an abnormal thing for this court or any court to do. For those reasons, again, I would pray upon the court as far as the decision is concerned, but as far as the Commonwealth is concerned, there's no request for the court to recuse themselves, and whatever judge hears the case is whatever judge hears the case. Thank you.
Do you want to respond, Mr. Jackson?
Very, very briefly. The only thing I would draw both the Commonwealth and the court's attention to is the person that made the statement, Sean McCabe, is related to Jennifer McCabe. He's a brother. He also didn't just throw sort of a dart at an empty dartboard. He hit the target because he made a claim that he had a personal relationship with this court, or at least his family had a personal relationship with this court. And that turned out to be at least some of the facts that he made, or that he claimed in the post, turned out to be true. And we've attached that. I'm going to be delicate about my comments here because it's sealed, and it should be sealed. That portion should be sealed or impounded. But it turns out that it's true, and the courts had an opportunity to see that. Also, with regards to the second post, it's also true in terms of the family members' names. It's not like they're just the family members' names, this court's family members' names, which I don't need to repeat here. But there is some fact-based information that troubled us because it turns out to be somewhat true. Now, the last thing that I'll say is that the Commonwealth's position was it may not be true. There's a bunch of invectives in that string of communications between the investigative reporter and Sean McCabe, and half that stuff may be true. And Mr. Lally's words were, I don't know if they're true. And that's the point. He doesn't know if they're true. I don't know if they're true. I hope they're not true. I desperately hope that what Sean McCabe said is not true, but it doesn't matter what I think. It only matters what the public perceives might be the case. And the word might is in the rule. It doesn't have to be the case. But a reasonable person looking at this from the outside looking in, if they're disinterested, might they think that the court has some relationship that would compromise the court's ability to be fair. That's enough, and at that point, it triggers this court's requirement to disqualify itself. That's all. We're not suggesting that the court is not fair nor impartial. Nor partial. We're suggesting that the public may perceive it that way, and they reasonably have perceived it that way. And I'll see you.
Okay. It's 2:35. I'm going to take a 15, 20-minute break to consider what I've heard here today. Obviously, I've read everything in advance. Let's
Thank you.
All right.
You are muted.
Yeah, they're like,
Guys, this is Kevin from Yellow Cottage Tales, and Dave is outside the courthouse. So he'll be interviewing people and talking to the crowd out there. Thank you very much for joining us. We'll be live again tonight from 7:30 to 9 with new information from Sean McDonough. My guess is right now the judge is pretending to be thinking about the arguments. This is the pre-trial hearing of Karen Reed, everybody. We're up to about 1,400 viewers, and the judge is on a break while she considers motions to recuse her. I'm not sure if they'll be discussing any more evidence in the case. I guess not. Our reporter, Dave McGrath, is outside the courthouse, and he'll be going on live as soon as the hearing is over. And then in addition, we'll be going on tonight at 7:30 live. So from 7:30 to 9 with Sean McDonough, who has some very compelling new evidence. It's so compelling and controversial that it's not something that I would report myself. But Sean is he's got the bill of goods. He's got everything we need. Sent me some pictures today that are extremely compelling, and I'm not sure which ones he'll let me put up. But Sean is doing fantastic work on this, and he's taking a lot of personal heat for it. So I'll get away from this again. I just want to remind you guys we're here. We'll be here tonight from 7:30 to 9, and then at 9 o'clock, people can switch over to Turtle and discuss some of the new evidence that Sean is going to be unearthing tonight. Thanks, guys. Hey guys, we're here at an intermission at the Karen Reed pre-trial hearing. I think the only decision being weighed on here is whether the judge should recuse herself. The argument was a little bit flimsy, but I'm not sure if the purpose was actually to get her to recuse herself or just to get that on the record, something that can be used later on, perhaps if they try to overturn this at the appeals level. I also just want to say I'm getting a lot of Facebook friend requests and calls. Great, keep them coming. Anybody on Facebook who wants to friend request me, take it on, and we do a lot of work on this case, so glad to have it. Thanks, guys. I'm going to step aside again, and hopefully the judge will be out soon. I want to just take a quick chance to talk to you guys for a second, where this channel is beginning a documentary series. We're starting to shoot for it next August, this August 1st, which is a week from today. Tom Fleming will be leading the production crew. The main subjects of this documentary are Dave McGrath, who's outside covering the case right now, so look for him and say hello, and Melanie Perkins McLaughlin, Emmy Award-winning director of Have You Seen Andy? And these guys have been studying for years, separately, independently, but arriving at the same conclusions. They've been looking at cases going back to the 1970s, and the question is, if they're finding evidence that predators were working together. And this potentially, if the information these guys are finding is accurate, this could be a scandal close to as big as that which was uncovered by the Boston Globe in the series The Spotlight, which they made a movie on. So Dave and Melanie are doing very important work. But the other reason we wanted to do a series on them, though, is because their own personal stories are extremely compelling. You can see more about that on our channel. But we'll be filming that on August 1st. We have a team of about 10 people. But if anybody out there wants to join us, if you like to hold the camera, if you're good at that kind of thing, if you want to help out with some editing, it's a one-day shoot for now. We're putting that together. That'll be material that goes into the first episode, but also the main purpose is to set up a trailer. So we'll be shooting in Lawrence, Massachusetts, and then at Bridgewater State Hospital. So if anybody's interested, reach out. Anybody that is interested in true crime, anybody that's interested in the production, the chance to work for at least a day with somebody like Melanie Perkins, who won an Emmy, and we're very proud of that, what she managed to achieve with that from our city. So please just reach out to us if you have any interest at all. And I'm going to get off here again because I feel like I keep interrupting, but there's nothing really happening at the moment. We're waiting any time for the break's over. And I keep reaching out with the Facebook friend request. Follow us on the channel. It's Yellow Cottage Tales. And we have an exciting interview tonight from 7:30 to 9 with Sean McDonough, who's a retired DEA agent and who has now become one of the more courageous people from the law enforcement community speaking out on the Karen Reed case. And because of that, he suddenly is flooded. He's bombarded every day with messages and leads. So he's got some compelling stuff. So please check in from 7:30 to 9. We'll be live. And hopefully we can get that information over to Turtle Boy. And then he can discuss it on what he thinks of this new information himself at 9 o'clock. And we'll all head over there and watch the show. Any of you that know me knows I'm not trying to take a side. I'm trying to look at the evidence fairly, objectively. There hasn't been a trial yet. So I know everybody has a lot of strong opinions. I just want to see all the evidence, and that's always going to be my approach to every case. But thank you guys for listening. Thanks for being here with us. I'm really glad to meet you, and I appreciate it. Thanks. And we're up to over 1,600 views, and that's pretty good for us. You guys, we lost the feed for a second. I'll just maybe refresh. See if that does it. Okay, it seems to be coming back. I'm not sure. All right, guys, we'll give it a. Yeah, I'm not sure if it seems to be from their end. Straighten out. I'll switch to a different channel. Lower the volume a little for you, so you can hear that. All right. Let me try another feed. Let's try the WBZ 4 feed. They're on a commercial. It seems to be trying to come back. We're having a lot of thunderstorms coming through the area right now, so I'm not sure if that's interfering with things in Canton or interfering here. We just had a thunderstorm pass here, so somebody can let me know if they're getting a better feed. I haven't been able to find one yet. Okay, Fox, so it's on 25. Let's try that. Severe thunderstorm warning. All right.
Austin police officer boyfriend John O'Keefe with her SUV while dropping him off at another officer's home in Canton for a party. O'Keefe's bruised and battered body was discovered the next morning. Prosecutors allege Reed returned to the scene and said, "I hit him 3 times in front of a paramedic." But Reed has maintained her innocence from the start. Her defense team says there's evidence to not only prove she's innocent, but that also points to a cover-up. They say Reed is being framed for O'Keefe's murder. They allege O'Keefe was brutally beaten and attacked by a dog inside the Canton home and that Reed is being framed for his murder. So in court today, the judge will decide on a pair of motions aimed at maintaining a fair trial. The hearing is set to start at 2 p.m. We will have a crew inside, and we'll bring you all those developments tonight. Reporting live in Dedham, I'm Julianne Lima for your local station, Boston 25 News.
And then a little bit of smoked paprika, really good color, and gives you a little bit of that smokiness. You have to season it, right? So this is a chance to season the rub. So a good couple pinches of kosher salt. That is good. These are the kind of rubs that you can have fun with. Make it your own. For the meat, I'm using pork tenderloin. And if you're asking yourself, why am I using pork tenderloin? Because it's cheap, it's effective, it's really tender, and it'll take on a ton of flavor, especially all the goodness in the rub. Now, to cut it up, I like to go lengthwise with it and then cut it into small pieces because you want it to.
I don't know, guys. Struggling to find a live feed here. The one on Boston.com is not going. It seems like the one on Channel 5 is just on hold while they're waiting for the judge to come out, but let's try it
Happening today,
again.
the Mansfield woman accused of killing her Boston police officer boyfriend will be back in court for a pretrial hearing.
It's a high-profile case. It's gotten contentious because the defense claims the defendant is
His name on the placard that was held up was Julie Nagel. I do not know her. I have never rented my house down the Cape to anybody, and I don't spell my name the way it was spelled on the placard, and I think counsel are well aware of that. And doesn't that underscore the fact that anybody can say or write anything and try to make it the basis of a motion to recuse? And I think it points out that this motion to recuse is not credible. There's no actual lack of impartiality. There is no reasonable or credible appearance of lack of impartiality. And I want to make it very clear that I reject the notion that untrue and unsubstantiated rumors spread on the internet can force a judge to recuse herself from a case. Simply because someone plays with my name or gives credence to those who do. By holding up a placard, you can't create a reasonable and credible appearance of lack of impartiality.
Jesus. I don't know, guys. I don't know, guys. Trying to get it back. I don't know. I don't know what the problem is.
proposed impingement on the media in this motion whatsoever. There is no proposed restraint or prohibition or impingement on the defendant, Ms. Reed, any conversations she wishes to have with the media. It does not prohibit defense counsel within the confines of the courtroom from making any arguments or zealously advocating for their client in any way, shape, or form. It also does not prohibit counsel from speaking to the media. It just seeks to prohibit counsel addressing the media or addressing the merits of the case within the media or using the media as a propagandist to advance its theory of the case. And essentially, I think the Supreme Court decades and decades ago said it best, essentially when it stated in Bridges versus California that legal trials are not like elections to be won through the use of meeting hall, the radio, and the newspaper. And obviously I would argue that that extends further to more current forms of media as well. But for the judicial system to operate fairly and impartially, attorneys must conduct themselves in conformity with their legal and ethical requirements. Defense counsel may represent their client zealously within the bounds of the law, but they are to treat all persons involved in the legal process with consideration and to uphold the integrity and honor of the legal profession. The issue that the Commonwealth takes note of with respect to how counsel has comported themselves throughout the entirety of this case, and this goes well beyond before Mr. Jackson, Ms. Little, or Mr. Henchy had even filed notices of appearance in relation to Ms. Reed. So this goes back to when the case was pending in the district court. But essentially, the issue is sort of what counsel has done as far as cherry picking certain items of evidence, completely divorced from the context within the body of evidence that has been provided through the course of discovery, and releasing certain pieces of evidence directly to the media. The filing of motions has been done directly to the media prior to any of those motions being sent to the Commonwealth.
Do you have proof of that, Mr. Riley?
Your Honor, the proof that I would submit is that what I can say as an officer of the court is that the Rule 17 motions that were just discussed previously in relation to animal control records and in relation to the cell phones, the first that I received those motions were from the press liaison from our office prior to receiving any email from either of the four counsel for Ms. Reed and prior to being CC'd on the email in which they were filed with the court. The last motion that the court just heard, as far as to recuse itself, was something that was filed on a Friday afternoon, late in Friday afternoon. It was discussed on a YouTube blog over that course of that impending weekend. It wasn't docketed with the court until that following week, either that Monday or Tuesday, and as the court is well aware, was then subject to impoundment. And the issue that I have with this, Your Honor, is that these motions, which contain sort of their facts or rank speculation as to what occurred in this particular case, not only includes those, but it includes, in specific reference to the Rule 17, references to certain witnesses, defamations of certain witnesses, as far as their personal identifying information, which I covered in a prior court date in relation to their names, their date of birth, their address, their phone numbers, their social security numbers, identifies a juvenile witness in this case, released post-mortem photographs of the victim, Mr. O'Keefe, directly to the media. These are things that are within the possession of both Commonwealth and defense counsel. And I can say I have said nothing about this case publicly to the media, and nor will I, while it's a pending case, nor do I plan to after it's not a pending case. These things were not released by my office to the media, and there's only one other source from which they could originate. The hyperbole or the language that's been used on the steps of this courthouse in reference to the Commonwealth having its foot on the defendant's throat in relation to certain witnesses within this case has then subsequently caused those witnesses to receive harassing phone calls, people driving by their homes, other harassment and essentially intimidation that has been caused by these filing of material that should be subject to either a redaction or impoundment before it's made public, made accessible to the public. Again, a couple of things in the opposition that counsel filed that I would just address at this point, being that their statements to the media are sort of purported to be reactionary as opposed to propagating some sort of thing. And the two sort of instances that counsel references in the opposition are some statement that was made well back when the case was pending in district court by the commissioner of the Boston Police. Commissioner of the Boston Police and the Boston Police Department as a whole have nothing to do with this case. They have nothing to do with the investigation in this case. They have nothing to do with the prosecution in this case. The victim in this case, Mr. O'Keefe, was a Boston police officer, but essentially, whatever statements were made by this person have nothing to do with the Commonwealth as it relates to this particular case. And then there's some other statements attributed to press liaison from the district attorney's office, essentially upon receiving requests from the media, informing certain members of the media as far as a date, location, and time, and the subjects or the charges that were to be subject of an arraignment, or subject of a conference, or whatever. Essentially, name, rank, and serial number is what was provided to members of the media. And that apparently then opens the floodgates as far as their reactionary statements and filings that they've made directly with the media while this case has been going on. The second piece is that it's talked about as far as concern or fear about prejudicing the prosecution. I'm not concerned about prejudicing the prosecution. Let me be clear about that. At some point in time, there's going to be a trial, and the jury is going to hear the entirety of the evidence and the entirety of the facts surrounding what happened in this case. The issue is about impairing the integrity of the judicial process. The issue is about harassment of witnesses. And I say witnesses, they're not Commonwealth witnesses, they're just witnesses. And to have them be subjected to or put through what they've been put through as a result of this, the Commonwealth felt that it was appropriate, probably well before this, but at least at this time, to file this motion asking the court to simply order that the counsel conform their conduct to the rules of professional conduct. That is all that this motion is asking for, and I'd ask that it be allowed.
Okay, Mr. Yannetti?
Thank you, Laura. May it please the court. An attorney's duties do not begin inside the courtroom door. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of an indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. Those are not my words, Your Honor. Those are the words of Supreme Court Justice Kennedy giving the majority opinion in the controlling case of Gentile versus State Bar of Nevada. The knowledge that every criminal trial is subject to contemporaneous review in the form of public opinion is an effective restraint on possible abuse of judicial power. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. Public awareness and criticism have even greater importance where, as here, they concern allegations of police corruption. Again, the words of Justice Kennedy. As for me, Your Honor, I have 3 words for this court. 3 words forming one question. How dare they? How dare the prosecution try to prohibit defense counsel from doing our jobs? How dare they ask this court to take away our First Amendment right to free speech? How dare they try to trample on my client's Sixth Amendment right to a fair trial and their 14th Amendment rights to due process of law? How dare they? Your Honor, I have represented Karen Reed since January 29th of 2022. I was hired not long after she was released from the hospital under psychiatric observation because she was that shocked and that distraught after finding her boyfriend, John O'Keefe, lying hopelessly cold and bloody on Brian Albert's property. From the beginning, she has faced a prosecution team that did everything they could to poison the well of public opinion. Before she was initially arrested on manslaughter charges, I formally contacted the Massachusetts State Police in writing and promised that if they took out charges against her, my client would fully cooperate. I confirmed that I would walk her in and surrender her wherever they would like me to do so. And what did they do? They completely ignored that promise of cooperation, insisted on arresting her so that they could parade her before the media. They got their perp walk, and the poisoning of the well began. And almost immediately thereafter, no less than Superintendent-in-Chief of the Boston Police Department, Gregory Long, came out immediately in public to declare that the state police and the Norfolk DA's office had arrested the person responsible for John's death. Superintendent Long did not caution that someone accused of a crime is innocent until proven guilty. He did not caution the public to keep an open mind. He did just the opposite. He announced in public for everyone to hear that in his opinion, Karen Read was guilty, and let's pat the prosecution on the back. That statement was broadcast on almost every media outlet. It was posted to the Boston Police official Facebook account. It was posted to the Boston Police official Twitter account. It was posted to the Boston Police official website. Right from the start, the Boston Police announced that Karen Read was guilty. Now, I ask you, Your Honor, where was Mr. Lally after that statement was made? What cautionary instructions did the Norfolk DA or the Canton Police Chief make then? Crickets. Nothing. We can only take from their deafening silence that the prosecution was quite comfortable when the media narrative was that Karen did this. There was no request for a gag order then. There was only silent approval. But of course, that was only the beginning. Immediately after Karen's arraignment in Stoughton District Court on February 2 of 2022, Superintendent Long once again seized the opportunity to speak to the media in full uniform, conveying that he was speaking in an official capacity. He lamented the loss of a fellow officer, quote, especially under circumstances like this, end quote. It was obvious to anyone listening what he meant. Circumstances of his girlfriend supposedly killing him, because that's what he already told the media. So from the start, they controlled the narrative, and as long as they did, all was well. They had Karen Read right where they wanted her, and with the public being told, there's nothing to see here, she hit him with her car, she's guilty, just trust us. And they were able to control the narrative and get away with it, I suggest to the court, because they withheld discovery from us for months. At my client's arraignment in Stoughton District Court, you can pull the tape. I couldn't even get a police report from the government. They claimed that no police reports had been written. They fought me.
When was that?
That was right at her arraignment in Stoughton District Court. They fought me when I tried to get search warrant affidavits. They stalled and delayed and hindered our ability to fight the narrative that they had put out there. And in the meantime, Canton Police Chief Rafferty was allowed to publicly state that the facts revealed by the defense were just, quote, sensational accounts, and they really should just trust the prosecution. Jennifer McCabe's attorney was allowed to publicly state that the defense attorneys were just spinning it, and it's going nowhere. He told the world, without evidence, that the whole scenario is baseless. The Norfolk County DA is allowed to suggest, regarding the timing of Jen McCabe's 2:27 a.m. Google search, which we can prove without any doubt. The Norfolk County DA suggested to the media that we may not have interpreted the raw data correctly. And then, of course, both Chief Rafferty and the Norfolk DA spokesman, David Trout, claimed that they were ethically constrained from commenting, but that didn't stop them from commenting anyway, publicly stating essentially that the defense is not to be trusted. So again, I ask you, Your Honor, where was the prosecution when all of that was going on? Where was the request for a gag order then? It's a rhetorical question, of course, because there were none. The prosecution was perfectly happy to have potential jurors hear all of this unfairly prejudicial information about Karen Read because it would help their pathetically weak case that they've brought against her. And the case is pathetically weak because they've arrested the wrong person, yet inexplicably, They refused to admit it. They were quite happy with the press this case was getting when it was in their favor, and their minions were out doing their work with the media. Of course, once the evidence, started to trickle in, the tide turned, and it did turn in a big way. In May of this year, Your Honor, we displayed the injuries to John O'Keefe's arm, I should say. Injuries that cannot be explained by a sudden motor vehicle collision. And all of a sudden, people took notice, and they started to question, hey, what really happened here? That was a seminal moment when everyone started to realize Karen Reed did not do this, but somebody else did. And for the purposes of this motion, it's important to note that the statements that we've talked about made by the Commonwealth and its representatives, some of those were made after we announced the existence of this exculpatory evidence in court. And it is also salient that our statements were made in court. In court. Their statements were made out of court. Can you imagine the hypocrisy of the prosecution now coming before this court to suggest that a gag order is appropriate? How dare they? Not only is it not appropriate, it's unconstitutional. Not only is it unconstitutional, it is anti-constitutional. We, not only as defense attorneys, but as U.S. citizens, have a First Amendment right to speak out consistent with our ethical duties as lawyers representing a client who's been falsely charged with a crime. We believe, moreover, that we don't just have that right. We have a duty to defend our client against the misinformation and the prejudicial statements put forth by the prosecution and their allies. Our founding fathers recognized that the power of the state is immense and can be far too powerful. So they enacted the first 10 amendments to the U.S. Constitution, the Bill of Rights. In its motion, the Commonwealth cites certain cases to support its request that the parties be gagged, but none of those cases stand for the proposition that a criminal defendant or her attorneys should be gagged. All of those cases address situations where the prosecutions acted impermissibly in poisoning the well against the defendant like they did in this case. The prosecution has the resources. They have access to local and state police departments. They have access to crime laboratories, and none of those resources cost them a dime. Karen Reed, on the other hand, has been forced to defend herself on her own dime. And by dime, I mean hundreds of thousands of dollars when she has no income as a result of these false charges. Thank God that a legal defense fund has been established to help her defend herself. She would not be able to do so without the help of perfect strangers and good Samaritans who recognize the worthiness of fighting the injustice in this case. So, the Commonwealth's motion for a gag order is hypocritical, it's unconstitutional, it's unsupported by case law. But let's shift for a moment, Judge, and talk about what would it accomplish. Will a gag order stop the media coverage of this case as I hear cameras going off behind my shoulder? Look at this courtroom. Does the prosecution think that if they stuff a gag in the mouths of Karen Reed's attorneys, that these good reporters behind me are simply going to go away? Do they think that the general public's going to go away? I think it's quite clear there is zero chance of that. The press is onto them. The press is onto this case. The press is not going away. The public is now quite interested and vocal. If you gag us, Your Honor, the extrajudicial conversation will not end. If anything, it will only intensify. A gag order will simply mean that we can't participate in it to correct misinformation and defend our client. And consider what that means. It means that the McCabe's and the Alberts and the Proctors of the world and all of their followers who have their heads in the sand and refuse to consider the outlandishness of the prosecution's theory can say whatever they want. They can talk about burying the body of reporters under a judge's house. They can slander and libel and smear Karen Reed, and we would be powerless to respond. How does that make any sense? We are well aware of our ethical duties. We have complied with them. We will continue to comply with the rules of professional responsibility and criminal procedure. We did not create this media circus, the prosecution did. We have every right to respond to their lies and misrepresentations. And in closing, Your Honor, it is said that sunlight is the best disinfectant. We ask you, Your Honor, no, we implore you not to partially block out that sunlight by prohibiting Karen Reed's attorneys from defending her both inside and outside the court.
Okay, I'll take this motion under advisement. Mr. Jackson, you said we still have outstanding discovery on the motion to compel.
There are a couple of matters that Ms. Little wanted to address.
Before we begin, I remember clearly that I ordered expedited testing from the lab on some items. I just want to know, this is what I've needed to go forward and ultimately decide this motion. I need to know the status of where we stand with all the discovery that is still outstanding.
So, Your Honor, where we stand is that, yes, upon the court's request, the Commonwealth had requested the lab to expedite some of the forensic testing. There was the criminalistics work that was completed. There is a trace assignment that was also completed. And there was DNA that was scheduled, that was exhaustive in nature. That was scheduled for July 11th.
Okay, I'm going to stop you right there. Was there more than that, Ms. Little, that you say is still outstanding? Mr. Jackson said you're going to argue this.
More than just the tissue samples, Your Honor?
I asked about the status of the expedited order that I issued way back. And Mr. Lally said that there are criminalistics, that there are trace evidence, and that there's DNA evidence. I didn't know if you both heard him. You were talking, so.
Yes, Your Honor.
Do you need to talk with Ms. Little before we finish?
Just one quick second.
Okay. Jim. Motion.
Your Honor, we've been requesting access to all of Mr. O'Keefe's clothing, all of the taillight pieces.
All right. Let's take these one at a time. Where do we stand with the clothing, Mr. Lally?
Yeah, I mean, what I can say as it pertains to each of the items that they're at the lab, there's still, so what I was getting to as far as the testing is concerned is, so there was initial round of exhaustive DNA testing that was scheduled with defendant's expert. We had discussed this on a prior court date.
Right.
From the subsequent trace and criminalistics analysis that have been done, there were additional items that were also selected for DNA testing, which were also exhaustive.
Okay.
I learned of that on June 2nd, sent another exhaustive testing form to Mr. Renee. Did not hear a response at all. So I reached out again on July 10th as his testing was scheduled. I reached out prior to July 10th, but I called his office on the 10th, only to find that he was out of the country. So that I spoke with Ms. Little and Mr. Jackson in reference to executing that form. Unfortunately, by the time that I received it on the evening of the 10th and forwarded it immediately to the lab, they were unable to take those samples out and prep them for the testing that occurred the next day. So now there's a second round of exhaustive testing that had to be put off because of counsel's delays to August 1st.
All right, let me stop you there. Is everybody in agreement that your expert's available and we'll be doing this on August 1st?
Your Honor, our expert's available to do the exhaustive testing on August 1st.
Okay.
The issue is that there's about 30 items of evidence that need to have DNA testing. Trooper Proctor, according to the reports, only submitted about 5 of those for testing. Our office has been requesting access to the remaining items of evidence for 6 or 7 months at this point, and we still have not received access to those.
All right, so the 5 items that have been sent have not been able to be tested because some of them have exhaustive?
A couple of issues with that. Trooper Proctor does not select items for testing. That's done by the lab. Secondly, as far as the items that have been requested, and Ms. Little and I've had, I thought, a fairly cooperative back and forth in relation to this, but essentially, the items that are at the lab are going to be at the lab until they're done with their testing.
Any idea how long that will take?
So I had inquired about that. I'm waiting a response on a couple of different items as far as reports completion. I believe the second trace assignment should be completed fairly shortly. The reports and anything related to the first round of exhaustive testing in relation to the DNA, which are separate items from the second, That should be reports that I expect to have. I think they had put an anticipated date of about September 5th. And then obviously, which gives it about a 6-week turnaround time. So just if I'm following in that sort of time frame, testing done on August 1st, reports should then be available sometime around the end of September, early October. That, I believe, would be the sort of, unless there is, from the testing that they're currently doing, then it leads to further need for testing of further items, then the testing should be complete at that point. One of the things that I had just done this week and just hadn't heard back from Ms. Little yet in regard to was, so there's been requests for inspection of items, there's been requests for inspection and sort of testing of items, and essentially what I'm looking for from counsel is some sort of itemized list of, counsel has the entire lab file up through, I think, about June 19th is when I received the packet from the lab up to that point. That's all been provided to counsel essentially the day after I received it, once I was able to copy it onto a flash drive. Obviously, anytime that any further reports or any other material is available, I'll forward it to counsel. I think we're on notice of discovery 19 or 20 or something like that at this point.
That particular issue, Your Honor?
Sure. Did you finish that point, Mr.
I
Lally?
didn't, no.
Let's let him finish that point, Ms. Little, and then I'll hear you.
What I had asked for was basically a list of which items do you wish to inspect, which items do you wish to inspect from either swab samples from or conduct testing on, so that, because it sort of depends on where that inspection could take place, and depending on sort of timing, that could affect things.
All right, go ahead, Ms. Little, on that point.
Your Honor, 2 weeks ago, I sent Mr. Lally an email. This is one of the reasons I wanted to respond to this in writing. I itemized every single piece of evidence, Your Honor, and I told Mr. Lally exactly which items you wanted to have access to, exactly which items you wanted to have tested.
Okay.
And we have not received a response from that as far as which items are actually being submitted by the Commonwealth to the lab. So that's where we stand right now.
All right, I think the two of you need to talk. I think you said that you had some cooperative agreement, Mr. Lally, that you and Ms. Little.
Hadn't really envisioned this as some sort of disparity or disagreement as to, as what I've maintained all along is as soon as the lab is done testing with the items, then counsel, can have access to them, inspect them, swab samples, do whatever they like within the, policies and procedures of the lab. So no, I welcome any further discussion. I'm sure it's something that we can hash out.
The issue, Your Honor, is that Mr. Lally is now indicating that none of this is going to be done until October. As the court well knows, he had indicated to us that this testing was going to be completed in May of this year. We're now months after the fact. This is a case that's been pending before this court for quite some time. And we're just asking for access to the physical evidence in this case so that we can conduct our own analysis.
Okay, but I understand that there was no response from Mr. Yannetti as to the trace evidence. So they weren't able to test it on the exhaustive testing because you didn't get back to them.
Mr. Lally did not copy us on the email. Mr. Yannetti was out of the country. As soon as he contacted my office, I got it to him the same day.
He did, but I sent it to Mr. Yannetti on June 2nd. He wasn't out of the country at that point. And since then, I have copied all counsel on every communication that I send just to avoid any further issues with that. And just to correct the court on a minor point, it was the second round of exhaustive testing for DNA, not for trace evidence. There is a second trace assignment that's being conducted.
Okay. All right. So, Ms. Little, I'm going to have you put in a motion exactly what you need that you still don't have. And Mr. Lally, you'll have to explain in writing why they don't have it, what the testing looks like on each item. That'll make it easier for me to rule on this and how long it will take. All right, but it needs to be in motion form, and you can apply, attach a memo that explains whether there was, no answer back from Mr. Yannetti, so it added another 6 weeks or whatever it was. Things like that, so it gives me some idea on why we're where we are. Okay?
Thank you.
I think that's it.
Your Honor, if I just one last thing as it relates to the motion the Commonwealth filed.
Voice up, please.
Forgive me. As it relates to the motion that the Commonwealth had filed with relation to the defendant's phone and the privilege log, I understand that the situation, I'm not asking for the court to take any action on the motion, but just imploring of the court essentially if the court has the means and time to expeditiously review that privilege log.
So I saw it this morning. It was relatively easy to take a look at. Ms. Little, I'm going to ask you, I can't see you behind Mr. Lally. It was relatively easy to take a look at and decide. So it's just 2 items, right? So I ordered that be redacted and that it be provided to the Commonwealth forthwith.
Thank you.
Thank you.
Okay. And that was with a hand. I just wrote it out this morning. I just saw it in the file. Okay. All right. Thank you very much.
Judge, I need to date. So we had discussed the date internally. I didn't have the chance to speak to Mr. Lally about this, but we were wondering if we could have the afternoon of August 30 as a first choice.
August 30th?
August 30.
That's good for the court.
No, it's not, Jim. I can't do it Tuesday, Wednesday, Thursday.
September 15th.
Hold on a second. Oh, I'm sorry. I'm sorry. Can we get another date?
September 15th, is that
Yeah. Does that work, Jim?
Yes, of course.
Does that work, Mr. Lally?
That's fine.
All right. September 15th.
9:15, 2 p.m., but for what?
Our status on the motions? Was there something else, Ms. Giannetti?
I think 2 p.m. For status, and then if any motions are filed and marked up before then, perhaps we could address them.
All right. I need to finish off this motion to compel. So
Right.
we'll figure that out. All right.
Thank you, Your Honor.
Thank you very much.
Thank you. Thank you, Mr. Burke.
Okay, the judge will not step down in the case of Karen Reed, who is charged with killing police officer John O'Keefe. Attorneys for Reed, who has alleged a cover-up by state and local police in this case where she is charged with killing her former boyfriend, Boston police officer John O'Keefe, unsuccessfully asked that the judge recuse herself. As the hearing got underway in Dedham District Court, Reed's defense attorney, Alan Jackson, asked Judge Beverly Cannon to step away from the case. The attorneys held up placards containing screenshots showing that the judge may have a personal connection to one of the witnesses. Prosecutors objected to the request. The judge left the courtroom to review the request. And when she came back, she told the courtroom that the request is not credible and she will not recuse herself. Let's go to Jacob Wyckoff now. We have some weather popping up across our region. Jacob, I know we had been looking at the potential of some rain showers this afternoon, but we're seeing some dark skies.
Absolutely. In fact, we do have a severe thunderstorm warning out for the next 5 minutes or so for parts of Boston as you go up towards the North Shore and into Essex.
Okay, guys, we'll keep on the channel 25 here in case they go outside the courtroom, but we also have Dave McGrath outside, and he'll be connecting to us as soon as he can. This was an interesting hearing, not as interesting as maybe some of us would have liked because we want to see some of the evidence discussed. But, you know, there's a lot of little motions that go on in these pretrial hearings. So, guys, thanks for being here. We're up over 2,000 total viewers. I don't know how that splits between the various channels that we're on, but please remember to subscribe, notify, whatever those things that apply to make sure you stay in touch with us. We'll be on tonight at 7 from 7:30 to 9 with Sean McDonough, who has a bunch of evidence, and including, to the extent that they'll let me show them to you, some photographic evidence, maybe some things you haven't seen before, and it could be pretty revealing of the case. I always try to take an objective and fair, balanced view of this thing. These photos that he showed me kind of steer us in. They're pretty solidly in the direction of conspiracy. I mean, would I call it a smoking gun? No, because you always want to, but it's close. I mean, you have to see. We don't know the context of things when someone just produces a photo, but it's pretty powerful and compelling stuff. If Sean decides we can't show the most compelling one, we'll just talk about it on the screen. Maybe I can do a sketch artist drawing of it or something like that. But we would definitely talk about it, and hopefully Sean will let us show what we can. So we'll be on from 7:30 to 9. Dave's outside getting ready to go on. And then at 9 o'clock, this has been a long day for me. We'll take a break and everybody can switch over to Turtle Boy. Just so everybody knows, I am not connected to Turtle Boy. You know, I do follow his show. I go on there. I have my own opinions, and he has his own. But we enjoy. I think everybody at our channel enjoys the show. So we do go on, and we respect his opinion. And he's broken a lot of big stories over the years. I only started following him with this case, but he's definitely been indispensable in terms of breaking news on this particular case. So thank you guys very much for being here. We're just on hold a little bit to see if they go outside the courthouse and to see if when Dave is ready to come on. So just to remind everybody, as I've mentioned before, we're doing a documentary series beginning August 1st will be the first day of shooting, so a week from today. Tom Fleming of Worcester and now of North Carolina is leading the film crew, but we're still looking for volunteers because we want to get everything we can and we want to have a fun crew. So we've got about 8 to 10, maybe 12 people going right now. We'll be shooting in Lawrence from about 9 to noon, so it's short suit. And then after that, we're going down to Bridgewater State Hospital. And this is going to be really compelling stuff. The subjects will be Dave McGrath, who is the author of the book and who's outside now covering the trial for us. He's the author of the book Monster, The Life and Crimes of Wayne Chapman. So please check it out on Amazon. Melanie Perkins McLaughlin is someone who is I'm particularly proud of because she's from my city and she won an Emmy for her documentary, Have You Seen Annie? It's on HBO and you can check it out. But Melanie has been digging into this Annie Puglisi story and other similar stories related to that in the 70s, as says Dave on his own. And I know they both have a lot of new evidence. Dave has a new book coming out. Dave's book goes into organized crime and some other issues too. So this is an interesting thing. And actually, it's one of those things where, Dave has warned me, and I don't want to put words in her mouth, but Melanie's concerned about this too, where reporting on this actually could put us in a little bit of make us think a little bit about at least a little bit of worry, because this touches on organized crime figure who is still alive and who was connected to all this stuff. So in fact, Dave got a visit for him when he first started reporting on this a few years ago. So we have to think about all this stuff very carefully. But for now, we're definitely going to follow the evidence where it goes. This will be an ongoing series that we'll be producing over the next several months. But it begins on August 1st. Anybody that wants to join us, please, we'd love to have you. So let me look in the comments and see if there's anything else coming. Still waiting for Dave to come on. See if anybody else wants to come on with us.
Someone said to me that I've
I guess I'm gonna
years giving back to the community.
please turn down the volume on this thing. I just have the feeling that Channel 25 is going to go outside the court. So maybe they won't. I don't know. But it seems to me that a big part of the story is outside the court. Now, last time, Karen made an appearance with her lawyers and made some statements. I don't think they're going to do that this time. But at the very least, you'll see Turtle Boy out there. And there's a lot of people feel very passionate about this case. Oh, there's something I forgot to tell you. This is really interesting and important. And hopefully Dave will get on this. Tom, Dave, we're waiting for Dave to check on anytime. So Dave reported to me about 10 minutes ago that there's a guy out there. Let me read this to you. This is really interesting. Let me get back. All right. He wanted everyone to know this, that he's standing next to a man in a suit taking pictures of every protester, and he's wearing an investigative unit shirt. So, according to Dave, and Dave's in law enforcement, so he has a good eye for this. There's somebody out there that's part of an investigative unit that is taking pictures of every protester. And I don't know what you guys think about that, but I find that disturbing. Is it not? Oh, I'm sorry. We switched. You're right, Jeffrey. We had to switch. We switched to BZ. It was and all that confusion when we lost the signal because of the storm. So I told Dave, I said, get some video of this guy. Now he's supposed to be going on right now. I hope they didn't arrest Dave. He might have tried to get some video of this guy who was taking pictures of everybody else. That would be particularly disturbing. Let me see if I can get him on the phone and make sure something didn't happen to him. So, because he didn't He also didn't even respond to my text. He was oh, geez. I hope his it went straight to voicemail. Wow. I mean, I'm worried that Dave is actually under arrest for trying to, and it'd be my fault, I guess. I mean, Dave, he messaged me to say that somebody was taking pictures that was wearing an investigative unit uniform or shirt or something like that. And they were taking pictures of the protesters. And I told Dave to get some video of him. So I hope they didn't look at that and arrest him. I don't know, but somehow Dave is off right now. Hopefully his phone just died. I don't know. But Dave may be hiding from the rain. Yeah, I don't know. I'm looking at the radar. It looks like it could be pretty bad right there too. So anybody else know what the situation is on the ground in Canton? Is it still raining? Has the line passed through there yet? It's pouring rain in Dedham. So that could be it. Hopefully that's it. Somebody told me Turtle Boy is live. But I guess if it's raining, he's not doing any kind of a rally. He must be just sitting in his car. If anybody has any information on that. Danny says it hasn't rained yet. So I don't know. So this is live TV, and I am not a trained broadcaster, so I'm doing the best I can, and thank you for putting up with it. I'm also not a trained technology guy, so we ran into issues. Dave did a fantastic job on the ground, but we were getting a feedback problem. I don't know if there's any even way to solve that, even if we had a mic, because maybe a professional setup running through a system could take out that feedback, but the feedback was coming from all the other phones and devices that people had that were broadcasting this stuff. So, Dave's calling me right now, so that means he's not arrested. Hey, buddy. Hello? Dave? Dave? Hello? All right, I hung up. He called and there was no connection, kind of like when Jen McCabe. Oh, let's try again. Hello? Must be struggling with the rain. Dave, you there? If you can, I can barely hear a voice at the end somewhere. I'm live, actually. So you're live too. We were worried about you because I told them how you were filming somebody that was taking pictures from the investigative unit. I can't hear anything, so I'm not sure if you're there. Dave? Yeah. All right. So I did kind of hear a voice very, very distant, like from 2 football fields away. So I'm not sure exactly what where the technology issue is, but there's a lot of people on cell phones at the same time out there watching stuff, and then you got the storms coming through. So we have a bunch of people at the courthouse. Someone named Liz. Liz is down from the courthouse. Is it raining there, Liz? And Violet looked around and can't find Turtle streaming anywhere. So maybe he's in a car. I have a collect call from Dave. Exactly. Do they still have collect calls? Is that still a thing? He was screaming help. Exactly. And someone said he's in McCabe's trunk. Well, maybe he might like that. I don't know. But investigative unit. What do you think that's about? Anyone got any ideas? Yeah, I mean, I find that disturbing because it's not like people were out there rioting. So there's no reason to be taking pictures. That's crazy if that actually, if that's going on. And Dave is in law enforcement. So he would have a pretty good understanding that somebody might be in that situation. So TB is still there. TB is following Carl Dugan and Paige. All right. So did anybody have any reaction to what they saw there today? I don't think there was any surprise. There was no surprise. I mean, to me, the whole idea of trying to get the judge to recuse herself. Listen, these lawyers that Karen has are way too smart to know that had a chance to happen. So I don't even think that was the purpose. I think they just wanted it on the record for later on down the road. If there's something they have to appeal, they can use that as part of a basis, or maybe they would just try and. I can't really think of a purpose why they would do it, but because you risk pissing off the judge, I think. But I don't know. Maybe they know that the judge is pretty thick-skinned and she doesn't care about that stuff. Because it was pretty flimsy. You're going to try to get the judge to recuse herself based on the fact that somebody, Sean McCabe, who is Jen McCabe's brother, kind of got into an argument with Turtle Boy online and said something like that, called Auntie Bev, called the judge Auntie Bev and implied that she's in that corner. But unless there was any truth to what he said, which it turns out, I guess there's not, that was not ever going to go anywhere. So Liz says it's stopping. So that's good. Hopefully Dave will get on soon. He is out there trying to. Dave is an Afghanistan war veteran, so I don't think the rain is going to scare him, but he may not want to get his phone wet. Dave, I've seen video where Dave was part of being interviewed when he was a young man on Dateline NBC in the middle of a battle. So Dave actually really did fight the fight. So we focused Tuesday with our documentary on Dave and Melanie and these cases in the 1970s. It's kind of a hot thing right now too. So we're getting various inquiries at different. Dave's getting some, and we're getting some. And but because I do screenwriting and I have had some stuff produced, so we're getting inquiries from Hollywood because right now the thing that's hot because of that movie, Sound of Freedom, is they're all looking for anything to do with child trafficking, which isn't 100% what I'm not sure. Dave doesn't fully come under that ground of his work, but it kind of segues into it. I mean, the kids were abducted, so I'm not sure if that counts in trafficking. But one of the cases that he was looking at, or he spent a lot of time looking at, is in a boy brothel in Revere that was busted. Oh, Dave's got a picture for me, so let's see if this is. Oh shit! All right. Oh, it's a picture with Eden, Turtle Boy. So I don't think that's the guy who's. I don't think Turtle Boy's the investigative guy. So hopefully you got some video of the investigative guy. Let me just check the comments. Can you switch the sound on the TV streaming? So what would TV streaming? There's nothing on though, right? Is there something on right now? There's nothing on related to the case. If you have another channel that's related to the case, I'd be happy to switch to it. Anybody? I'm just looking through the comments to see if anybody has anything on that we can switch to. So, okay. Tom, our production manager, says we can kill the WBZ. So I'll kill it. I just thought they might end up outside the courthouse. So it's gone. So if anybody sees anything interesting coming up on one of the other channels, I'm just amazed that maybe because of the rain, I thought they'd be outside the courthouse filming the rally and stuff like that. So I'll get rid of that. But if anything comes on, let me know. We'll put it on. I'm not sure how long we're going to stay on here. If anybody has anything that they want to talk about, if anybody has a really compelling story, if they want to come on, I'll send you the stream link and you can talk about it for a few minutes with me, because we're coming back on at 7:30 and we're going to be interviewing Sean McDonough, and he has a lot of interesting stuff. So for many of you out there that are listening, and we still have over 1,000, so obviously send me friend requests. Please subscribe to the channel, but also find Sean and find Dave McGrath. If you have any tips to any of these child trafficking cases or cases that relate to the disappearances of these children in the 1970s, but up to the present too. Oh, here's Dave now. Let's see another shot. Dave? A little bit, yeah. Yeah, it's the rain, yeah. Oh, shit. Okay. Oh, no, we were worried about you because we didn't hear back from you, and I'm still live right now, so people can hear me. But last I heard from you were taking videos of that investigator, so we were worried you got arrested. Okay. All right. Excellent. So are you heading home now? right. Well, man, hopefully you get to take a little nap because I know you got to work your late shift on duty tonight. All right. If you don't take a nap, we'll take you back. We'll take you on, obviously, but we're not trying to push you. Right. That's how I feel. I've been sleeping like 4 hours a night the last few nights. So, but that's normal for me lately. So, all right, cool. Thank you very much, Dave. That was Dave. The reason he hasn't been able to go live is his phone got wet in the rain, but he did manage to get a lot of video. First, I think he said he got video of Karen leaving the courthouse, but then he got a lot of video of Turtle Boy. He sent me a picture of him and Turtle Boy, sharing a photo and kind of laughing about it. But he got video of the rally or whatever was going on with Turtle Boy too. So we'll share that later. It hasn't uploaded to my phone yet, so I can't share it yet. But I will share it with you at some point today, either on the channel or on a website or something. Maybe we'll show it tonight. We'll probably show it tonight on the video when we go on live at 7:30, so you can watch that. But I don't want to show too much of that because I want to get right into Sean McDonough. I mean, I talk to Sean every other day now. I talked to him for about an hour and a half this morning, and it's just, we go back and forth in the case, and he's just getting tips and stuff flooding in. Because the thing is, obviously the main guy getting tips on this case is going to be Turtle Boy, and probably always will be, and he deserves to be. But sometimes if someone is in law enforcement, they want to give their tips to someone else in law enforcement. And Sean is a retired DEA agent. Sean is also getting threats and other people. And he's actually was telling me a story today from another friend of his who is a retired law enforcement officer. I don't actually even know the name or where he was a law enforcement officer. I think it was Boston, possibly a Boston suburb. I'm not sure. But this guy's retired, and he has coffee with a bunch of other cops with Sean or something like that. And this guy told him that he got a visit the other day from, I believe it was someone from the Boston police, off duty, of course. And they showed this guy a picture. We'll have Sean tell the story tonight in case I got some part of this wrong. But so the cop came in and he showed this guy, a retired police officer, a picture of this guy at a rally for Karen Reed. One of Turtle Boy's must have been last week's rally for Karen Reed. And so they threatened him. They basically said, if you're with them, we got a problem. Is basically what they did. So this is where we're at right now. I mean, you've heard of the thin blue wall. This is it in action, and I'm all for the. So who's a moron? Am I a moron, disposable dad, or are you talking about someone else? If I'm a moron, tell me why. Maybe we should bring you on the channel and you can tell me why I'm a moron. I always welcome that because it's always fun. But anyways, so where was I? Oh, so yeah. So apparently these guys are threatening other, retired law enforcement people, anybody that is not down on the Brian Delbert's team, which is, I find incredibly, I don't know. I mean, it's disturbing to think that it's not surprising, I guess, but it's disturbing to think that this stuff is going on, So let's check for comments and see if anybody else has any more ideas, because I'm running a very thin wire because I've been up till late last night doing these things and all day on this. So let's see. Just want to say, yeah. So let's see. Any more comments here? So you think they're going to be approaching or bothering anyone that goes to the rallies? I don't know. What are they capable of? What would they do with pictures? What could you do? What pictures? What possibly could you? Oh, you know what? Actually, if they're taking pictures, it could be something similar to what Sean was talking about, where they're just looking for people in the group that they can target, maybe someone else that is in law enforcement or former law enforcement. So this could be just a way of intimidating people to not, especially law enforcement people, to not take the Karen Reed side, which find that incredibly disturbing. So, see anybody else is on here. The way these motion hearings are going suggested Adam Lally won't have to prove anything. Yeah, we'll see it. You're welcome, Val. We're working hard. We're doing our best. I want to thank the team, Dave McGrath, obviously out there in the field. Dave is working third shift tonight and for the Bristol Sheriffs, but I have the feeling that he's not going to take it. And I've been talking to him since 7 a.m, so he's been up early. I get up at 5:30, and Dave's, I guarantee he's going to come on the show later. So just the last few comments. John Curran is back. Yeah, I mean, that's how trials are, Sean. You know, I mean, that's the American justice. You saw when Ladley was mumbling about how long, what they need to do to get them the evidence that they're entitled to. It's now some of the blame, contrary to what we hear, actually does seem to also go with the prosecution. I'm sorry, with the defense team. So, for instance, when they have DNA, they have a very limited amount of DNA. And it's not like they can just say, okay, here's a piece for you to test and here's a piece for us to test. Sometimes what happens in these cases is both sides have to agree on an independent testing house to test it. And that's a negotiation. So everything that goes on is a negotiation. This also goes on with the black box data. So, I did a lot of research on the black box, and apparently with the black box, even it's not, you would think that it's just like taking the information that's on a hard drive or on a flash drive, and then once you got it, and everybody can have a copy. But apparently the very process of downloading that information from the vehicle can affect the information. It's especially if the vehicle lost any power during an accident, I think would be a problem. So that didn't happen in Karen's case. But I think typically what they have to do is, in order to get that black box data, they actually have to have both sides agree on a time and a place where certain experts will come in and take out that data. So there's it's a fascinating thing to see what goes on with these cases here. Jeremiah is ex-law enforcement himself. So what do you think, Jeremiah? Are law enforcement officers taking a chance by speaking out here or showing up to a rally? I know I've seen Jeremiah here before and at Turtle Boy site before. So curious to what you think. Yeah, they're taking chances. That's what Trevor G says. I agree. It's a brotherhood. And I mean, you think it's an awkward case though, because even if it's a brotherhood, you think they should be protecting brother John O'Keefe. And it's one thing to protect people when it comes to speeding tickets and stuff like that, but this is a murder, and it might involve the cover-up of a murder. So there should be no thin blue line that applies to that. If these guys are really sure that Karen is guilty, then they need to just step away and let the trial process go forward, and let the trial go forward and let the chips fall where they may. Don't interfere. Don't be out to be out there trying to intimidate people. Well, we got to catch them in the act doing that. Hopefully Dave got some pictures of that. Hopefully somebody got some pictures from that, because if they're going to be doing this kind of shit, we as a citizenry have to put a stop to it. I mean, I've tried to be fair and objective on this case. I'm not out there trying to push any particular side, but we can all look and see there's an incredible amount of strange things in this investigation that at the very least were extremely shoddy, but they seem suspiciously a lot more than shoddy. But if you want to restore the reputation of law enforcement, don't be out there trying to take pictures of people and intimidate people and send threatenings. That's bullshit. So Megan says, I heard because the car was driven after the accident, the black dogs can't detect the actual event. No, that's as far as I know, that's true. Not true. What I found out, Megan, was this: you actually, it stores up to it'll reset itself after 200. It basically, it's like an old VCR tape. It'll just, once it gets to the end, it starts recording over it, but it stores quite a bit. So I think what I saw was you would have to restart the ignition on your car 200 times. And each time that would start pushing it back until eventually you got rid of the older event. Another way is it only stores 5 crashes. Any collision that's over 5 miles an hour. So if you get in an accident and want to erase that data, one way to do it would be to go out and get 4 or 5 more accents, and then it'll erase that. But of course, you'll probably get into more problems with the new accents. But I'm not advising that, guys. I'm just talking hypothetically. Commonwealth never has discovery to provide in a reasonable amount of time. They rely on police report to support their case, and then when it comes for the discovery, it's delay, delay, delay. I'm not a lawyer in the system, or so maybe I believe Mark. I mean, maybe that's a problem. I'm sure that's a problem. You got these public employees. Sometimes they just aren't motivated. And it's funny how Larry made a comment about it being political, and then we hear about the person taking pictures of the crowd. Yeah, exactly. And actually, Giannetti did, and was it Giannetti or Yannetti? I forget. Yannetti, I think. He did an incredible job pointing out that the prosecution managed to frame the public's opinion about this for months, and now their position is that yes, they're trying to change the narrative in the media, and obviously the courts don't want you to try a case in the media. But if they don't do that, they're at an incredible disadvantage because of the damage that was done by the prosecution in the opening weeks and months, and really the opening year of the case. So they just kind of they're saying what they want to do is balance that off. You've got to change the public narrative. So obviously they've managed to do that. Shamrock Sports. If you guys love local sports in Worcester, Shamrock Sports is the guy, especially South High School, I think. So go check out Shamrock Sports Network 508. It's on YouTube. It's on Facebook. I'm not sure what else is on. So Shamrock, I only know that because I see him commenting here, and I know he's got a really cool channel. He talks to a lot of fighters and basketball coaches, and he covers the sport, the sports of both genders, male and female. And time to break. All right. So he says nothing changes for him until we get the 2 minutes of missing library footage. And that's true. I mean, I'm going to end with that. You try to watch the case fairly. And one of the things that bothered me was that back in that hearing in May, when the defense explained to the judge that there's a gap in the video. They called it a gap in the video. So Karen Reed is picked up on film from the library, on surveillance video, driving from downtown to the 34 Fairfield Road where the Alberts live. She's picked up. Then she's not picked up when she drives by the library to go home. She was living with John O'Keefe. Then she again is picked up by that same surveillance a few hours later at 5 a.m., when she's returning to go back out. Now she's going out looking for John. And it's very suspicious because what they're trying to, so when they show her going from the waterfall downtown to the house, the Albert house, her tail light is fine. But then later on, when they show her at 5 a.m. driving out looking for John, you can see the tail light is broken. But what they need to get, because we do know that later on she backed into John's vehicle around 5 a.m. in the driveway. So the question is, did she break her taillight then, or did she break it? That's what the defense will say, or did she break it earlier on John O'Keefe's head, which is what the prosecution is saying. Well, suspiciously, that piece of video when she drove by the library on her way home from 34 Fairfield Road, that piece of video is missing. Now it's described by the defense as a gap. Now, I don't know exactly what that means. Is there literally like a suspicious 2 minutes missing? I don't know. And I thought that might, at least when the defense talked about that, I thought the prosecution might at least present an argument as to how that could have happened and it's not suspicious. They didn't. This was last May. And all he really said was, well, you know what? They got the same video that we got. And I don't know what to tell you. That's basically what he said. He didn't try to explain this gap in the tape, which is really, really, really disturbing. But guys, I want to wrap this up because it's been an extremely long day. I'm glad to have been here with you. I'm glad to have you. Man, we're still at about 700 viewers. We'll be back at 7:30 We'll have Sean McDonough on, and I'm pretty sure we'll have Dave McGrath on at some point during that show too. And we'll bring you right into 9 o'clock, and then you can check out Turtle Boy's show. But thank you guys very much for being here and for caring about justice. All right, guys, thanks.